Yes.
Back to,
Yes.
back to mention item number 14 and 15. I am for the petitioner, my lord. Mr. B.K. Singh appears for the respondent FCI. He's also not here. Can it be listed next Monday, madam?
Let's pray for by Mr. B. Pangi, Land Council for the respondent. Let that
Petitioner, madam. I am for the petition.
14 and 15.
Yes, 14 is an IA filed by the FCI.
Okay. So you are for the petitioner.
Yes.
Land Council for the petitioner. Have you informed the respondent?
In fact, he told me to make a prayer for.
Okay. Okay. Mr. D. Pangi, Land Council for the petitioner. Some states the Land Council for the respondent requested him to make a prayer for listing this matter on Monday.
Monday.
The prayer is allowed. List this matter on Monday accordingly. Okay.
May I, Your Lordship?
Yeah.
Lordship, I beg to mention item number 18, Your Lordship. We have not received any instruction for the department, Your Lordship. So at least 2 weeks time may be given, Your Lordship.
May I please, Your Lordship? Your Lordship, I am for the petitioner, Your Lordship.
Okay.
Yes, Your Lordship. And in interim was supposed to consider today, Your Lordship.
Your Lordship, interim may be considered on the next date, Your Lordship.
Okay. Miss.
Yes. Yes.
Miss.
A Talam.
Land Council for the petitioner is present. Miss Pango, Land Government Advocate. Chami Stat. She is yet to receive an instruction. They yet to receive an instruction.
No, Your Lordship. We have not received the instruction, Your Lordship.
Okay.
So it
You're
is,
waiting for instruction.
yes, Your Lordship. At least
Okay.
2 weeks time may be given and
Therefore,
interim may be granted
Pray
next
for
date.
further 2 weeks time to obtain instruction and to file necessary affidavit in opposition if required. The prayer allowed. List this matter. After 2 weeks, stop. The interim prayer shall be considered on the next date. Okay.
Almost obliged, Your Lordship. And also item number 8, Your Lordship. This matter to be listed on this Friday, Your Lordship.
8.
This Friday, Your Lordship. We have
Have
not
you
received
informed
any
the other side?
instruction. Yes, Your
The
Lordship.
petitioner.
Yes.
My lord, I'll inform Mr. Tony Partin. Last
Okay.
time, my lord, the Honorable Court has directed us to take the instruction. My lord, we are yet to receive any instruction, my lord. So
Okay.
can this matter be taken up again on 8th, my lord, Friday?
On 8.
8th, yeah, day after tomorrow, my lord. Yes, my lord.
Okay. So he is also ready on for 8.
Yes, my lord.
On the prayer of the Land Council for section and for respondent
Number 4.
respondent number 4.
Hmm.
On the prayer of Mr. Harris Navam, Land Additional AG, for the state respondent. Let this matter be listed on
8th, my lord,
8.
Friday.
Okay. Okay.
Obliged.
Lordship.
Hmm.
I'd like to mention item number 10, Your Lordship. Here we have to file affidavit, Your Lordship. So some time may be given.
Affidavit.
I've taken the consent.
Okay, Ms. Vesa, Lannis. You are for respondent number, state respondent.
1 and
Okay.
2.
Government advocate. For the state respondent with the consent of the Land Council for the petitioner, praise for.
3 weeks time to file affidavit.
Okay, you are seeking 3 weeks time to file affidavit,
Yes, on behalf of respondent number 2.
respondent number 2. And you are for?
But for petitioner, my lord.
You are for the petitioner.
Yes, my lord.
Okay, no objection.
My lord, the interim order, yes, my lord, that will continue, my lord. Interim order pass, earlier may be continue.
Item?
10.
Then, my lord.
10.
Okay, sorry. Mr. T. Land Council for the petitioner is present. Ms. Vesa, Land Government Advocate. Praise for further 3 weeks. 3 weeks time
Lordship.
to file affidavit in opposition. The prayer not being objected to by the Land Council for the petitioner is allowed. List this matter after 3 weeks. Interim is there.
Yes.
The interim order passed earlier shall continue till the next day of listing. Okay.
Obliged.
May I, Lordship, I beg to mention item number 9.
Item 9.
Yes,
Yes.
the matter may be kindly adjourned for today and maybe list after vacation. Lord.
Oh, no objection.
No.
Okay. Mr. Land Council for the petitioner Praise for adjournment of the matter for 3 weeks.
After vacation,
Okay. The praise for listing this matter after the interim
break.
winter
Winter
vacation,
break.
to which Mr. T. Togum, Standing Counsel for the Execution, for the respondent has no objection. Accordingly, the prayer is allowed. List this matter after the ensuing winter vacation. Okay.
Deeply.
Hello, sir. I beg to mention item number 21. We have taken consent from other parties,
You are for?
petitioners on behalf of the Tapak,
Okay. When do you want?
after 2 weeks.
Okay, Mr.
B. Sivo on behalf of the Tapak.
Land Council appearing on behalf of Mr. T. Tapak, Land Council for the petitioner, with the consent of the Land Council for the respondent. After
2 weeks.
praise for listing this matter after 2 weeks, the prayer is allowed. List this matter after 2 weeks.
Lordship, it's maybe interim, maybe continue.
The interim order passed earlier shall continue till the next date of listing. Okay.
Deeply.
May I please, Your Lordship? I beg to mention item number 2. Leading counsel is out of station, Your Lordship. Can this matter be listed after winter break?
Item 2.
Yes, Your Lordship.
Okay. Mr.
M. Tasso on behalf of IBAM.
Land Council. Submits that the leading counsel, Mr. I. Bam, is out of station. Therefore, pray for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks.
There is an interim order, Your Lordship.
There is interim here.
Yes.
Item 2.
Yes, Your Lord.
The interim order passed earlier shall continue till the next date of listing. Thank you. Item 2. This is why it has been listed in motion.
yeah, madam, I was supposed to get instruction, my lord. I've been instructed.
Okay.
This is for the third time, my lord.
Hmm?
This is for the third time, my lord.
Mhm.
Still, my lord.
So after vacation, it will be listed on motion or,
Motion, my lord.
okay. Okay.
Item number 1.
No one appears on behalf of the petitioner on floor. None appears for the petitioner on call. Huh? Forensic of justice. Let this matter be listed next week. Okay. No, not adjusting it. Only also remain absent. After 2 weeks. Okay.
Item number 3.
Please, Your Lordship. This is regarding suspension, Your Lordship, though no review was done in this case, Your Lordship.
Yes.
Lordship, the suspension order, which is at page 31 is the suspension order.
Hmm.
It was issued on 30 January 2025.
Hmm.
Below, it's on top 30 January 2024, it is written, but it was typographical mistake maybe.
Hmm?
It was typographical
Which one?
mistake. Suspension order dated 30 January 2024, it's written.
Which one is
Page
typographical
31.
mistake?
Page 31. And
31.
yes, annexure 3. Lordship got it. Below
Which
is the
one is that?
digitally signed.
Hmm?
Below is the digitally signed on 30 January 2025.
Hmm.
Is the right date, Your Lordship.
Which is incorrect?
30 January 2024 is incorrect, Your Lordship.
Incorrect.
Yes.
Which one is correct?
Below digitally signed, it was corrected. 30 January 2025.
Okay, 24 is incorrect. Okay.
Yes, Lordship. Thereafter, Your Lordship, petitioner has reported his duty. And then
Duty?
station report, Your Lord. After suspension,
Okay,
direction was issued to report to the head office, Itanagar, Your Lordship.
okay.
Accordingly, he has reported. Thereafter, page 34, Your Lordship, is the typed copy of suspension extension order, Your Lordship, which was issued for a further period of 180 days, Your Lordship. It was issued on 23rd April 2025. And then in the meantime, petitioner submitted representation and all. My basic contention is at page, that is suspension extension order is
Thirty-six.
the extension order is at page 36, Your Lordship.
Hmm.
Which was issued on 18 November 2025. Kindly, may I read, Your Worship, the relevant portion?
I've seen. Hmm. Yes.
It was extended for 180 days, Your Worship. So my contention is that this extension of suspension order was issued after a lapse of 22 days. Therefore, this is not a valid suspension.
Yes, Mr. Prabhu.
My lord,
You're for,
I'm for the respondent number 2, my lord,
okay.
Education Department. my lord.
Hmm.
At this stage, my lord, notice may be issued, my lord.
Notice.
There is a prima facie, it reflects 22 days delay, Your Lordship.
But. Okay.
Which was affected from 1 May 2025.
Okay. Mr. A.K. Singh, Learned Counsel for the petitioner. By filing this petition, by this petition, the petitioner challenge the suspension order dated 30/1/2025. The subsequent extension order dated. Where is the prayer?
Extension order is page 33.
Okay.
Type copies at page 34
Hmm.
on 23rd April 2025. Which was annexed page 34. Your
Are you also challenging this 23rd April
Yes,
2025?
Yes,
Hmm?
Your Lordship, yes.
Okay, 23rd. 23, 4, 2025 and
18 November 2025.
18 November 2025. Whereby the suspension of the petitioner has been extended for further period of 180 days.
Which was affected from 1/5/2025.
Which was
Affected from
affected
1/5/2025.
from one
1/5/2025.
no, this is the last order 28/10/2025.
Lordship, I'm on suspension order dated 23 April 2025, page 34. Third paragraph.
Okay, then in the first, second order, extension order dated 23rd,
Yes, 23rd April 2025.
23, 4, 2025, which was affected from, then, just a minute, whereby the suspension of the petitioner has been extended for further period of 180 days
Yes.
with effect from 1/5/2025 and the order dated 18/11/2025
The
by which the suspension of the petitioner has been further extended for extended for further period of 180 days with effect from 28/10/2025. So thereafter you have submitted these representations.
Lordship.
Okay. It is it is submitted that the extension order extension of the suspension of the petitioner was issued on 18 November 2025.
Which actually expired on 27.
To be effected from 28/10/2025 after the delay of how many days you say?
22 days delay.
22 days of expiry of the statutory period, stop. The petitioner further submitted. Okay, just a minute. After expiry of 22 days in violation of
Rule 10(6) CCS rules 1965. Lordship.
Rule 10 within bracket 6 of the CCS within bracket CCA rules 1965. Staff. The petitioner further submits that he has submitted a several representation on 8/9/2025, 8/12/2025, and 10/12/2025, seeking reconsideration of the suspension and enhancement of subsistence allowance. But the same remain pending without disposal. Staff, para issue notice. Issue notice returnable by 4 weeks.
Worship, just after vacation, sir.
Okay, 4 weeks. Okay, since
After
Mr.
vacation.
Miss Basar accepted notice on behalf of the state respondent number 1 and Mr. Togum for the Togum Land and Standing Council for the respondent number 2 accepted notice on behalf of the respective respondents, no formal notice need be issued. Stop, para. List is matter after 4 weeks.
Otherwise, Lordship, this is a prima facie, it appears. no?
Hmm.
This
In
is
the-
a fit case for suspension of the
Okay.
extension order.
See,
In the meantime, the state respondent is at liberty to dispose of the representation submitted. Representation submitted by the petitioner including the prayer for enhancement of subsistence allowance. So we'll give time then, till then, we'll say till then only, okay, during this period, notice period,
Yes, ma'am.
okay. List is matter after 4 weeks, okay.
Item number 4. My lord, before that, my lord, if your lordship permits, I want to just make one small submission, my lord.
Yes, sir,
My lord, this item number 8, I am told that this has been mentioned.
yes,
But my lord, today is fixed for, this is a fixed matter for consideration of the interim order. Lord, if not today, at least then on my Monday, Lord, the 8 will be too far, my lord. I'll inform RH Napom. No, I should have been informed earlier.
okay.
Item number
Who
8,
mentioned, Mr.
RH Napom.
Kamal was also present,
Yes, he's for the private respondent. I am for the petitioner.
okay. So,
If
yeah,
not today, my
8 is fixed for? 8 January, when do you want, you said?
either
have-
Monday
Then
or
in that case,
Tuesday.
you have to inform the other side.
Yes,
as well.
I'll inform 23 or 20.
No, no, let him be present, he's there. Who mentioned this matter?
We'll
Hmm?
inform,
RS Navam.
yes. I will
Some
inform,
AG mentioned. And probably with some reason.
but then again, in the 8 will,
I think it's fine only. We'll take up on 8 only.
otherwise, yeah, Friday. The 8 January. Well, he's mentioned for this Friday.
Okay, then it's fine only.
So-
This Friday or 8?
This Friday, Your Lordship.
Okay. 8 January.
Well, let it be on Monday 22, Malad. Friday is
Huh?
18, Friday is 19,
Monday, okay.
22.
Monday, I don't know. I don't know, unless you inform him,
Yes,
you'll inform.
Yes, Your Lord.
Okay. On Monday, then.
my lord, that interim order shall be considered on the day, my lord.
It's there only, I think,
Hmm.
in the last order.
Yes, last order
It's no problem.
of life course.
Item number 4.
Yeah. May I please this honorable
Yeah.
court, yes. Lordship, this petitioner has been compelled to come before this court fourth time in this year. On early fourth time, this is the fourth rate petition.
Okay.
Earlier on 2 occasions, he had come when transfer orders were passed illegally, and this court was pleased enough to interfere into those transfer orders. Now then, suspension order, your lordship. The lordship may kindly come to annexure 1, page 25 of my rate petition. This particular suspension order is dated 13th October 2025, signed by Secretary Power. Whereas Sri Niranjan Kumar Jha, Executive Engineer, Daporoji Electrical Division, Daporoji was placed under suspension by government order number so and so, dated so and so, 15 July 25. The case was placed before suspension review committee constituted by government order number so and so, dated 13/10/25, meeting of which was held on 13th October 25. The suspension review committee recommend for extension of suspension order number so and so, dated 15 July 25 for further period of 180 days. Now, the mathematical calculation made in this behalf here, or concerning this particular order, your lordship, in both the circumstances, if we take into consideration the date on which the extension was made and the date on which the original order was passed, it is more than 90 days, your lordship. At page number, I have made that mathematical calculation. Right. Page number 16, your lordship, of my rate petition. Paragraph 18. May I read, your lordship?
Para 20.
Para 18, page number 16 of my rate petition.
Okay. Yes.
That your petitioner states that the petitioner was placed under suspension by order number so and so, dated 11/7/25, communicated by memo number so and so, dated 15/7/25, and the review for suspension was conducted on 13/10/25, which is apparently not before the expiry of 90 days. In fact, review is beyond the period of 90 days as detailed herein below. So, lordship, I have calculated the days which has taken in between passing the original suspension order and the review. So in both the counts, once we take into account 11/7, then also it has, if we take into account 11/7, there is a delay of 8 days. And if we take into account 15/7, there is a delay of 2 days, your lordship. Because on 12th of October, the 90 days passed, if we take into account 15/7 date of effect, and if we take into account the original order 11/7, 8 days has passed. Now, this particular provision of law has been well settled by our High Court, as well as the Supreme Court, as well as the various High Court, your lordship. Now, our High Court in the judgment reported, in case of Binay Kumar Singh versus Union of India and 5 others, it was decided on 18/10/2023. Now, page number 3 of the list which I have submitted, your lordship. Page 3, paragraph 3. The petitioner is posted with the National Highways and Infrastructure Development Corporation Limited.
Your Lordship has got it. On deputation, pursuant to certain allegations in the discharge of his duties, an order dated 1/11/2022 has been passed by placing the petitioner under suspension. It is not in dispute that the aforesaid order of suspension was received by the petitioner on 7/11/22. The requirement of law to conduct a review within 90 days of the order of suspension was done on 3/2/23. It is the contention of the petitioner that such review being done beyond the prescribed period of 90 days, the same shall not save the authorities from their responsibility, which is mandatory in nature, and therefore the impugned order of suspension is required to be set aside. The contention of the respondents on the other hand is that though the date of the order of suspension was 1/11/22, it was communicated only on 7/11/22. It is accordingly submitted by the respondents that if the aforesaid date is reckoned, the review done on 3/2/23 would be within time. Therefore, there would be no violation of the law laid down. Now, the next relevant paragraph will be 5, Your Lordship. Sri Bora, learned counsel for the petitioner, has submitted that there is no manner of doubt that the order of suspension is dated 1/11/22, though the same was received by the petitioner on 7/11/22. The date for the purpose of the mandatory review within 90 days has to be reckoned as 1/11/22. It is submitted that the suspension takes effect from the date of the order itself, that is 1/11/22, and not from the date of receipt of such order. He submits that though the review has been done, the same was done only on 3/2/23, which is beyond the period of 90 days. He submits that the period of 90 days had expired on 29/1/23, before which date no exercise of review was conducted. Then paragraph 20 and 21, the concluding paragraph of the judgment, Your Lordship. Paragraph 20, page number 10, Your Lordship. It is admitted position in the instant case that the review of the order of suspension was done only on 3/2/23. It is clear that the said review was not done within the mandatory period of 90 days as required under case, Your Lordship. The review has not been done within 90 disputed. It is apparent on the face of the record that in either case, if we take into account the date of the order as well as the date of communication, after the period of 90 days, the review has been done. So dated
Stand. Twenty-one,
2110.
2025. Where is the, where in the prayer you have challenge or made prayer regarding the DE?
Page 20. Page 21. Roman 1.
One.
Page 21, Roman 1.
Article of charges
Yes.
and where is this order?
Annexure 10, Your Lordship.
And the order
10.
dated 1/9/2025.
Yes.
And
Page
it's, sir?
56.
Take 56. And also the article of charges ran against a petitioner by memorandum dated what stuff, huh? It is submitted that although the petitioner has submitted a statement of defense stroke reply in respect of article of charges and the extension just a minute. Have you submitted any representation against that?
Yes.
And a
17, 10,
representation
20.
against extension of
There are 20, page 17.
okay, expansion of his suspension order dated 13/10/2025. Just a minute. Submitted, but the respondent authority has issued the impugned extension order dated 13/10/2025 for further period of 180 days without assigning any region. As required under the law and in gross violation of rule 10(6), rule 10(7) of the Central Civil Service, the services within bracket CCA rules 1965. Staff. Issue notice. Returnable by 3 weeks.
3 weeks, my lord.
3 weeks. Staff. Since Mr. N. Ratan Learned Additional AG.
I appear for respondent one.
Appear.
Mr. Parme will be appearing for
Accepted
2, 3, and
notice
4.
On behalf of the state respondent number 1. And Mr.
L.
El
Perfect.
Parme for respondent number 2, 3, and
4.
4. No formal notice to be issued. However, the petitioner shall furnish requisite extra copy to the Learned Council appearing on behalf of the respondent during the course of the day's staff. List this matter after 3 weeks.
Along with
Along with
WPC number
No.
318 of 2025
WPC number 318,
of 2025
2025
and 220 of 2020.
and 220 of 2025. Stop para. We'll say that in the meantime, you can issue, because it appears that prima facie it appears it was only after the expiry. So,
Consider
pass-
his representation, madam.
okay. In the meantime,
May I submit one thing, Your Lordship?
the state respondent is at liberty to review the suspension afresh by passing region order strictly under the is strictly in accordance with
Law.
this, in accordance with, let's say, this rule,
Rule 10, 6
rule 10.6, comma,
and
rule
7.
10.7 of the CCA, CCS within bracket CCA rules 1965.
Till then, Your Lordship, annexure may kindly be stayed till then. Because
it-
since they will be reviewing the order which has been communicated to us.
Hello, this is
So if
of
both the orders
October.
will be,
Already 2 months
Hmm.
has lapsed, my lord. This order was of October.
Let them dispose of, while
Yes, yes.
disposing of, probably they review, and then they, by then they would understand
Yes, my lord.
and pass necessary order till return,
so there,
let
there,
them dispose
there
of.
may be some specific direction, Your Lordship, that the interim matter will be disposed of on the next date.
Then, okay, that will be within 15 days. That
Yes, 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 Your Lordship.
representation will be disposed of, review, no? Within 15 days. The the interim prayer shall be considered on the next date.
Okay.
Oblige, Your Lordship. Good day, Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, by way of filing this petition, we've put to challenge the order passed by the learned ADC of Kamba, West Siang District, that is at page number 20.
Just a minute. Oh, it was referred to the mediation.
Yes, Your Lordship, this case was previously referred to mediation, but since the parties were not ready to mutually settle it there, the matter was again sent back to this honorable court for disposal.
After referring before the mediation, this is the first time,
This is the-
it has come before this
This is
court.
the second time.
Or
It
second
was
time.
listed
Okay,
about
that order
a week
already
before.
passed. So in the office note, okay. Not yet been admitted.
It has been admitted. This is listed for final disposal, Your Lordship.
It has already been admitted.
Yes, Your Lordship.
Then why it has been listed for admission?
Malad,
Should have been listed for hearing then.
for admission hearing, Malad, that's why.
Admission here is
We-
already admitted. Why it is admitted?
Both the parties agreed that matter will be disposed of. That's why.
In the admission stage.
Yes.
It has already been admitted. Now it will be listed for hearing only. What admission hearing?
In admission.
It will be
stage-
for final hearing only.
Yes.
Now, after admission hearing done, that is why it was admitted.
It
It will be listed for hearing. We'll fix the date
Your
Lordship,
Lordship-
may
since the
dispose
parties
of
are present.
the Lordship can dispose of at this stage.
Now,
also.
now it will be hard only. Detail would be hard now. Since it has already been admitted. We'll fix it for hearing,
There was
already
urgency,
admitted.
there was urgency, Malad, that's why this matter.
What is the urgency?
One of the, he is constructing a house in the disputed plot line. And he has a stay order from this one.
There is a stay
Yes, Malad.
against you.
Yes.
It failed before the mediation. I did.
After getting stay, Malad, he's changing the status of the disputed plot of land.
The stay is to maintain status quo
No,
The
and
order,
to refrain from carrying out
staying the order,
and
for staying the order passed by the ADC. Because on the face of it, the order is completely illegal, Your Lordship.
order passed by the additional deputy commissioner
yes.
was a state.
Yes.
What is the order of the deputy commissioner?
It was to maintain status quo among the family members and not anything on the plot of land. Since
Okay,
the dispute is
That has
between
been
the family
stayed.
members,
that-
that has been
so
stayed.
now construction, construction,
After
going
getting
on.
stay, he started constructing
okay,
house.
it is under the petitioner's possession.
This is common, Malad, undivided family property.
The respondent is the biological brother of the petitioner. They are
Biological
all
brothers, Malad, petitioner and
brothers.
respondents.
The same family land.
That's why after getting stay, Malad, the ADC have passed status quo order. Nobody should construct. But after getting stay from this honorable court, he has started constructing.
Your own brother.
Yes.
So what's the problem?
Malad,
Just a minute. huh?
consensus should be
Just a
there.
minute.
but
Let
that's-
us see the ADC's order. What is
Page number 20, Your Lordship. If I may read, Your Lordship,
page 20?
page 20. There were three applications. There are three, one was a complaint under section 145, which was submitted by the respondent herein, private respondent.
Hmm.
There was,
One,
there was an application that was submitted by the respondent to the ADC under section 145
okay,
to proceed.
CRPC.
Yes, Your Lordship,
Okay.
to restrain the petitioner herein from constructing anything on the land.
Hmm.
And then there was a report from the police department saying that there was an FIR that was registered
Against?
against the mother of the petitioner. So if Your Lordship may come to the order, if I
FIR was lodged against the mother.
by the mother against the respondent and his wife, because they had raised their hand on the mother. So there
Hmm?
was some
They-
kind of a violence that took place between the mother
Okay.
and the respondent.
Father
and
is
his
still
wife.
alive?
Father is now deceased, but at that point of time, he was alive. So when this
Wh-
matter
when
was
this-
still
when this
pending, he
dispute-
passed away.
When this dispute started,
Yes,
Father was still alive.
he was still alive.
Okay.
And if your lordship may kindly note this application that the respondent has filed, he has filed in the name of the father, but then the father himself has not signed. So this shows that the brothers signed to manipulate the property without the consent of the father, because the actual owner is the father, but now he's deceased and that property is undivided. So there's a dispute that is going on among the brothers.
Okay, it is admitted that it is undivided property,
Undivided.
but now you are constructing.
Now we are constructing because
Why?
that land is being constructed by the mother herself. Like it is
Hmm?
for the mother
Mother.
of the petitioner, so that she can live in a better space.
Just a minute. Yeah. Who are the respondents? How many
There's only
brothers?
one private respondent,
Only one private
one
respondent,
private respondent,
only one brother.
one brother.
Who is elder?
I'm the elder
Petitioner.
brother.
Petitioner is
the-
elder.
Yes, Your Lordship.
Respondent is younger. And then the mother is with the petitioner.
With the petitioner.
I think we have to hear it. The detailed hearing is required. It appears.
Definitely it will
Mhm.
require detailed hearing.
Mhm.
That is
That
why
is
it was
why
fixed
it is-
today, Your Lordship, for
Hmm?
hearing. It was fixed today for disposal because on the last occasion, this honorable court.
Now, it will take
took up the
time.
matter.
We'll fix it for hearing on Monday or it's Tuesday.
Your Lordship, I will not be available. I'm
It-
going out of station.
If this is hard, then because the other matter will not come. Not reach.
This will not take that long, Your Lordship, because the matter is very simple. I'm only contending that the order
Oh,
of the ADC
if
has been,
This will not take time.
it will not take much time. It will
Okay,
probably
then
take half
then
an hour.
settle there. You don't consult because it is a undivided property. Undivided property, admittedly undivided property. What right you have got to construct? Unless it is divided.
But Your Lordship, we've not come here to decide who the land belongs to, who has the
So
right.
that-
We're only
So
challenging the
that way,
order
if
of
it
the
is short,
ADC.
then that way is easy. But then you see, you have to hear detail.
Your Lordship, if
From
Your
both the
Lordship
sides.
will kindly see whether the order of the ADC is sustainable in the eyes of law or not. That is the only point herein.
Okay,
So the way in which the ADC has
let
passed
us
the
see
order.
the complaint. Complaint lodged by the father,
Complaint lodged by the respondent, the brother.
brother. You said that father signed,
Father sign is not there. On behalf of Tumpak Karga, he's saying,
so that is why I'm saying,
but it is him who has filed.
okay, he signed it.
He has signed, he has filed, but saying that he's on behalf of the father.
Okay. Where is that?
Page it starts 27, madam.
Twenty-seven.
Yes, starts from 27.
27 is
Hmm.
is before the court.
27.
28, madam.
Hmm?
28.
It's a complaint,
Yes,
complaint case.
yes.
Whether the complaint case disposed of?
Yes.
No, this particular application was filed under section 145 before the learned ADC.
Page 28, madam.
Before the court of deputy commissioner, additional deputy commissioner, executive magistrate.
Yes.
From page number 28, Your Lordship can see.
Okay. Page 28. Yes.
At page number 24 also, there's this forwarding letter that was sent by the
Hmm?
OCPS. Forwarding letter at page number 24.
What forwarding it? Forwarding of
I'm
what?
forwarding here with the below noted FIR given by Shri Tojo Karga, IPS, Shri Pagmi Karga and Shri Topik Karga. These are the brothers of the petitioner for construction of permanent structure on the undivided family properties at Kamra Town.
Just a minute. No. We were at 28, page 28.
Yes, Your Lordship.
So this complaint proceeded.
On the basis of this complaint,
Hmm.
on the basis of a forwarding letter that was sent by
Forwarding letter,
at page number 24,
forwarding of what?
there was an FIR that was
FIR was also filed, apart from the complaint.
not registered, but an FIR was given by the other three brothers.
There are other brothers also.
There are two other brothers, including, excluding the respondent herein. So in total, three other brothers. They
No.
had also filed an FIR, and the mother has also filed an FIR against.
When this complaint was lodged? Complaint before the additional deputy commissioner?
I believe it was on 20th April 2000,
28 April.
20th April 2023.
Okay, and then when the FIR was lodged?
13th March 2023.
Okay, FIR was
The mother
prior.
has also filed a complaint.
FIR was lodged before the complaint. FIR was lodged by whom?
One FIR was lodged by the brothers against the petitioner. Another FIR was lodged by the mother of the petitioner and the respondent against the respondent and his wife. So the mother of the petitioner has also filed an FIR against the respondent. The respondents have filed an FIR against the petitioner. And there was a complaint that was filed by the respondent before the ADC. So all of these three things were taken into consideration by the ADC, and then he has passed an order.
FIR was also, FIR lodged by the mother and the brother also taken up by the ADC.
Yes, yes, yes. Your
FIR was not registered before the police.
Not registered.
Why it was forwarded to
It was
the
forwarded
ADC
to the ADC.
instead of carrying out the investigation,
Yes, yes, Your Honor.
instead of registering the case.
Now, my contention is that under the Civil Courts Act, the ADC does not have the power to adjudicate matters under as a civil or a criminal judge anymore. So
Okay,
now,
both the FIR, counter FIR, I mean, it was a counter FIR?
not counter FIR, different. The brothers have filed a FIR saying
FIR for what?
saying that the petitioner is constructing the land illegally,
Okay,
and there were some altercations that took place between them, and the mother has filed and the FIR against the respondent because the respondent and his wife had assaulted the mother.
okay. So altogether, different cause of action,
Different causes of action.
but both the FIR were also, FIR was lodged before the OCPS probably,
Yes.
mother as well as the respondent.
Yes.
And considering that these are from the same family, it was forwarded to the ADC
Yes.
without registering.
Yes, Lordship. Your Lordship, the FIR that was filed by the mother, that particular case has been registered and the case is still going on before the trial court. At this
You
point.
said that it was forwarded.
But it was forwarded on this particular order. If your Lordship will look at the order, the ADC has taken into consideration these three things, and then he has further
For-
moved on.
No, you said that it was forwarded before the ADC.
Yes, Your Lordship. So that is what the ADC has divided these three things into 5 issues. If your Lordship will look at the order, there are 5 issues that the ADC has formed. And
No.
he has taken up.
Again, you says that the case is still pending. The mother's FIR is still pending
Yes, it is continuing before the trial court. So that's
before the
what-
trial court.
If your Lordship may just allow me to.
No, whether with the forwarding of the FIR before the ADC, whether it was not end there.
That is what your Lordship, the ADC has after that formed 5 issues, and he has moved on to decide issue number C and E, and A, B and D, he has handed
No,
over again.
just first clarify. After forwarding of the FIR lodged by the mother as well as the respondent to the ADC, whether police has kept anything else, anything after that for the police investigation,
Whether the police has,
whether the police has kept the FIR still after forwarding, whether the police has still kept the FIR lodged by the mother.
No, because the ADC has directed.
No, you said that the case is pending. Which case is pending? Forget about ADC now. You first submitted that it was forwarded to the ADC. Okay? FIR lodged by the mother.
If there was an FIR that was lodged by the mother,
Hmm.
an FIR that was lodged by the brothers. The FIR that was lodged by the brothers was forwarded to the ADC. That is at page number 24.
Okay, this is only the FIR lodged by the brother.
Yes, Your Lordship.
Okay, then what about the FIR lodged by the mother?
That,
You said
that-
that earlier said that mother and father, it was forwarded. A mother and respondent forwarded, it
there
was clubbed together.
There was an FIR that was forwarded by the OCPS.
Which FIR?
The FIR that was lodged by the brothers. But
Okay.
there was also an FIR that was lodged by the mother.
Okay, what
And
happened to
that
that?
particular case is going on in the trial court.
Okay,
And
so
there is a,
in that particular FIR, investigated into charge sheet file and trial is going on there.
yes, Your Lordship.
Okay, that is separate, okay.
If Your Lordship will look at page number 22. There was this complaint also that was filed by the mother. This complaint was also taken into consideration by the ADC. That she was being assaulted by the petitioner or by the.
See, what do you mean by complaint and FIR? Mother lodged two, one FIR, one complaint.
Mother had lodged this complaint, which is at page number 22, to the ADC.
Oh, see so many things coming one after another.
This
22.
complaint. So basically, there was this complaint by the mother, the forwarding FIR of the OCPS, and the complaint that was filed by the respondent under section 145. These three things were taken into consideration by the ADC, and then the impugned order was passed. That is my submission on. The FIR that was registered for assaulting, that is also there, but then that is going on before the trial court. That's a criminal matter that is going on.
Okay, mother has lodged two,
Yes,
one
Your Honor.
FIR and one complaint.
One
Complaint
to
is
the
regarding what?
police and one to the ADC. The ADC.
Before the
complaint
ADC, what is this?
at
What
page
is this
number
for?
22.
Hmm.
Para 1, it says, I have been physically assaulted 5 times by my daughter-in-law, EP Karga, and manhandled twice by my son, Pakmi Karga. I have been keeping quiet all these years, but I can't anymore. At these declining years, as I was beaten by Dow mercilessly again, as late as 19 February 2023 by my son, Pakmi Karga, when I visited the Rupin paddy field to inspect the ongoing work there. My predicament is that not just confined to violence against me, manhandling and threatening Pakmi Karga and his wife only. That is what this has been mentioned.
Okay. So for assault, she has also lodged a FIR before the police, which
Yes.
has been registered, investigated into, and then
And that
trial is
that
going on.
Yes, Your Lordship.
For the same incident, she has lodged this complaint also before the ADC.
Before the ADC. So what ADC has done is, since this was a matter which concerned the same family, and there was a complaint that was filed by the mother, a forwarding of an FIR that was there, and a complaint under section 145, which was there. So he has clubbed all of these 3 matters and then formed 5 issues, out of which he has taken up only 2 issues, and then the rest of the issues he has again directed the
Okay,
down
just a minute.
side.
Now, ADC has taken up this complaint lodged by the mother against the respondent.
Respondent number 3.
And where is the FIR of the son?
That is at page number 24. The forwarding letter. Typed copy is at.
No. This is only forwarding. Where is the complaint FIR?
We do not have the FIR on. This is, since this was the document that was forwarded to the ADC, this is the document that we've retrieved.
Okay. The FIR lodged by the respondent. Let's forward this. Is there any other case
No, Your Lordship.
beside this?
I believe there are no other
Karga?
cases besides the ones
Karga.
before this honorable court.
See the name again, see? FIR lodged by whom you said? Was forwarded. This is by
Three of them,
Tikar.
Tojo Karga, Pakmi Karga, and Tope Karga.
Okay, who is the respondent then out of these three?
Pakmi Karga.
Okay, you are not. Okay, these Tojo Karga and Tope Karga is not before us.
No, Your Lordship.
But FIR was lodged by these three brothers.
Yes, Your Lordship. But then the application was the 145 application, CRPC application was lodged by
Against whom?
by Pakmi Karga, by the respondent hearing against the petitioner.
Against one application, complaint under 145 was only against Pagmi. Okay. So these two, the FIR lodged by these three brothers and a three brother against Pagmi.
Pakmia Karga, the petitioner.
Hmm?
Pakmi
Petitioner is
Karga,
Pagmia.
respondent. Your Lordship.
Petitioner is
Pakmia Karga.
Pagmia. Okay, where is the complaint by Pagnia? There, Pagnia has not lodged any. Only mother has lodged.
Mother has lodged.
Or that has not been clubbed together.
That has also been clubbed. Complaint and complaint, that is at page number 22. This issue was also taken up, and this issue was at
This mother
Number D.
has lodged this complaint against
respondent herein.
respondent
his wife.
Pagmi.
Yes.
Only Pagmi,
Yes, Your Lordship.
not against Tojo and the other one. Okay. So let us see the order now. ADC order
Page number 20, Your Lordship.
20.
20. If I may read, Your Lordship.
Just a minute. 6 March. March. when when it refers to two sons, which two sons?
It may be the petitioner and the respondent. At which?
Hmm?
Your Lordship, on which page?
Page 20, first paragraph. Your law and son Sri Pagmi Karga and claims undivided family property by her two sons.
Two sons means the petitioner and the respondent.
Okay.
Your Lordship, two sons, I believe it will be Sri Tojo Karga and Pakmi Karga, the respondent.
See. Difficult. Even you are confused.
No, no.
Hmm.
Because the sentence is such that is a little confusing. It will be Sri Tojo Karga because it is written Sri Tojo Karga and Sri Pagmi Karga neglected her welfare. Instead, she was assaulted by her daughter-in-law and son, Sri Pagmi Karga, and claims undivided family property by her two sons.
Oh, by two sons.
Two sons would be the two sons that is mentioned on top, I believe. Lordship.
You say they are not claiming. They are not before us. You
They are
said
not
that they are
before.
not
The
claiming.
Tojo Karga is not before us.
Hmm. Where is this additional petition filed by Pagmi?
That is the 145 application at page number 20 that Lordship has seen before.
Who is the petitioner here? Name?
Paknya Karga.
But it is under the possession of Tumpak Karga.
Tumpak Karga is the father.
On May 23, Tumpak Karga was still alive.
Yes, Your Lordship.
So whether Tumpak Karga has given it to anybody, any of his son before he,
No, Your Lordship. He died before dividing the property.
still it is undivided.
It's undivided still.
So although the problem arises when he was still alive, but then he passed away without dividing the property.
Yes, sir.
Who is this Tumge?
Lordship.
Tumge Karga?
Mhm.
Hmm?
Tumyil.
Tumge.
The brother of late Tumpaka. Brother. Yeah.
What was the decision of the additional ADJ?
Tumge Karga is the brother of the father of the petitioner.
Hmm?
He's the brother of Tumpak Karga, who's the father of the petitioner. Uncle,
So Tumge is not before this court.
I believe he is also there.
What is the decision of ADJ, Basar, on 15/6/2015?
It was in favor of Tumpak Karga. The land, this dispute was actually between this Sri Binken Nomuk and Sri Tumpak Karga. So
Tumpak.
Yes, Your Lordship. In that particular case, the title suit, it was decided in favor of Tumpak Karga. That is the father of the petitioner.
It appears Tumpak and Tumge.
Tumpak and Tumge.
Where is Tumge? Is Tumge is also claiming the said property? Because the court decided in favor of your father and your father's brother,
Brother.
Tumpak and Tumge.
Yes, Your Lordship.
Whether the Tumge is anywhere, is claiming or made party to Tumge? Because
this
he's also the
particular
owner of
case,
the
he's
party,
not made
owner of the property.
In this particular case, is not been made.
But
party.
he's the owner again, decided by the court.
But we are here only challenging the order of the ADC, which does not.
So
concern-
ADC mentioned that one. ADC has mentioned that the property belongs to Tumpak and Tumge.
Then in that case, Your Lordship, all the other brothers.
that is
and
why,
everyone
have
has
you
already
made
a
party?
They
Have
have
you
made a party. Because they are not going to be affected by this order.
But then the law says, but the judgment says it's belong to the Tumge also.
But we've not challenged this particular order. The title suit has not been challenged in this case.
You are not challenging this ADC order.
We are challenging the ADC order, but not the title suit. In the title suit, Tumge Karga is a party. I can implead them, Your Lordship, but then it will take another 2-3 months again. And this matter has been pending since 2023.
See, in the title suit also pending where Tumge is also defendant. Huh? Have you seen?
Yes, Your Lordship.
Hmm.
That is also one of the grounds in this particular petition, that this matter, this title suit, it's still pending before this honorable court. There's an appeal that is still pending before this honorable court. And while
Appeal before this court.
before this court.
That is why I'm asking if is there any other case pending in between this party?
No.
She said again.
No.
What is pending?
the title suit that was between the Nomuk party and the Karga party. We are the Karga party. So that the dispute between the Karga and the Nomuk parties are still pending.
Where,
Because the land that was
where it is pending?
it is pending before this honorable court. And when a civil matter has already taken up before this honorable court, the
It says
ADC could not
nothing is
pass.
pending.
Not between us, there's no.
Between us, there's no matter pending.
Okay,
Between
you and
another party.
you with
The
other,
Nomuk- Yes,
not
yes.
connected with this present land.
Connected to this particular land, but between the other parties, because the Tumpak Karga, who's the father of the petitioner, he had purchased this particular land from a party called Nomuk, Yamo Nomuk. But now some other people, Nomuk party, they've come and they're claiming that this particular land was not purchased by Tumpak Karga, but it was given to him only for staying for some time. So there was a Kaba that was held, and the title was also decided in favor of Tumpak Karga, which is the father of the petitioner. But against that, they had filed an appeal before the district court Alo, and then Obasar, and then thereafter that particular case was also decided in our favor, in the favor of the petitioner's father. And then the other party has now filed an appeal before this honorable court against that particular judgment.
Not, that means not finally decided.
Not finally decided. Now, when a matter, that is exactly my point, Your Lordship. When a matter is pending before this honorable court, whether an ADC could have passed an order under section 1.
When the appeal was filed? The appeal is pending since when?
If Your Lordship may kindly come to page number 78 of my petition, that is FAO number 1 of 2016. Was filed in 2016, and this matter is still pending before this honorable court. At page number 81, Your Lordship will see her learned counsel for the petitioner also heard Mr. So-and-so learned counsel for respondent. This is an appeal referred against the judgment and order dated 15/6/2015 passed by the Additional District and Sessions Judge Basar in Basar Title Suit number 60 of 2024. The appeal is admitted for hearing. Call for the relevant LCR. List the matter for hearing immediately after receipt of LCR. Now, this matter is still pending before this honorable court. And according to the records, this matter was last listed on 19th November 2025.
Okay, so you are agreed by this additional ADC's order.
Yes, Your Lordship. My contention is that when a matter is pending before the honorable court and the civil court is taking care of that matter, whether the learned ADC could have passed an order under section 145 CRPC. And the law is clear, Your Lordship. The Honorable Supreme Court also says that once a civil court has taken a matter into its own hands, the ADC cannot pass any such order under
Yes.
145 CRPC.
Your Lordship has seen the matter very clearly, Malad. The plot of land is there, belongs to the father of the petitioner and respondent, Malad. And four brothers, Malad. This land belongs to the father of the petitioner and respondent's brothers. Malad. Now, admittedly, the petitioner has
So
started.
it doesn't belong to the petitioner.
No,
No, doesn't belong to the neither respondent.
No.
It belongs to your father,
Our father.
not yet decided, and that this is disputed.
That's why we are undivided, the land that is admitted by both the parties. So what all the brothers are saying is why you have started constructing a house in that undivided plot without asking other brothers. That's the only simple matter here. And there was chance of violence if he forcibly starts constructing a house. Therefore, the ADC has passed an order to maintain
Now, you
status.
all brothers are
Yeah.
against the
His
others,
he-
others who claims title, isn't it?
particularly the petitioner.
Hmm.
We are saying petitioner should not construct any house in the plot of land.
Now, in one side, you all brothers,
Yes.
other side, who is claiming the title? The title is pending before the court.
That is different matter, Mother.
Okay,
That is totally different.
the title is yet to decide,
Yes.
yet to be decided, okay, isn't
So-
it?
If title is yet to be decided, Mother, why he should start constructing a house there?
And then you all together claiming or fighting for title of the land against other family,
Yes.
isn't it?
Yes.
So, but now you are fighting among yourself.
Yes, for that particular plot of land, not for
Re-
other.
Okay, assuming that land belongs to you.
Yes. It belongs to all of us, Mother. He's single-handed.
Whether
Yes.
the other side, who is the respondent or petitioner
Yes.
in the title suit,
Yes.
is agreed by her construction or the petitioner's construction.
No. Brothers are concerned, Mother. All other brothers, three brothers.
Not the person
Yes.
who
No.
is disputing the
No.
title.
No. Therefore, if they're taking the garb, under the garb of that matter is pending, Mother, he starts constructing a house. There's the changing the status of the land, Mother. That belongs to all of us.
What is the total area of land?
That particular, that dispute is totally different area, Mother.
Hmm?
Total area of land is 17,358.60 square meters, but then
How many
Yes.
children you said?
Four
brother.
Yes.
4 brothers.
So according to you, you are constructing in your share.
Yes, Your Lordship, because since the land belongs to the family,
Hmm.
the eldest brother, the petitioner, is constructing a house for the mother so that she can live in a better space. That is the main thing. But then the brothers
So-
also are wanting to occupy that land.
So this was actually a good case for settling before the
Mediation.
mediation.
They do not
Because
want
you
to
all
settle.
claiming, four of you are claiming the same land, claiming the title against other person. So you have a 17,000 square meter. 4 person can be divided, and if it is in the portion of where the mother or the brother, the petitioner is entitled, that can be settled within the party after the settlement of the title suit.
Yes, Your Lordship.
But
But then in any case, probably the ADC doesn't have this power to
Yes.
decide.
definitely this is, the ADC has not decided the title as such, Mother.
It appears.
No, Mother.
What
Title
is
has
the
not been
decision then?
decided, Mother.
What is the decision?
Lordship, page 20.
Yes, from the above fact, it is satisfied. Kindly read 21.
Yes, Mother.
Plot is an
Routine
undivided
is in the plot-
family land. He has decided a title in favor of your family.
No, Mother, what he's saying is that the residential plot is undivided family property. That's he.
See,
that's the-
undivided.
Yes.
He is saying now undivided.
Yes.
Whether the title is still pending. Title suit is still pending, isn't it?
Yes, Your Lordship.
That is with other party, my lord.
Okay.
That is, this plot of land
So
is
this
small.
court should also not tell the other party.
This is a small plot of land from that 17,000 square meters, 1,700 square meters. This is not the, otherwise that land belongs to the two brothers, Tumpak and Tumge, my lord.
See, cannot be undivided. So family land plot is undivided family land, which is in possession of so and so,
His father, my lord.
claiming of the property by any members of the family without the consent of the title holder. See,
Yeah.
title, he now declared title holder is Sri Tumpak Karga.
And he's not even there before.
Not even mentioned again, although he mentioned earlier that Karga brothers. What was the name of the other Karga?
Tojo Karga, Pagni Karga.
No, the brother of this Tumpak.
Tumge ka.
Tumge.
Karga.
Now he has forgotten that Tunge also. Because it is supposed to belong, this lane is supposed to be the lane of this Tumpak and Tumge, isn't it?
Yes.
Now he is declaring that title holder is Tumpak. I think this order, the ADC doesn't have that probably jurisdiction. He has exceeded.
Otherwise, this is, this order was passed based on the application 145 CRPC.
Now 145 said then status quo could have been passed.
Yeah, that's why the lastly status quo order was. Last second paragraph.
Now you see, here by this order, the wife, you are saying that you are constructing house for mother. Mother is also debarred from carrying out any construction.
No, it's specifically to the offsprings, not to the mother.
All the family members, including wife, it says. See last.
And now after the death of the deceased, the wife is the legal heir of the Tumpak Karga.
But by this order, now whether she received those how she inherit, or how can she, or there is any written document, any will,
The succession certificate has been.
succession
granted
certificate
before.
obtained, and whether this property also mentioned.
No, property. is
cannot
not
be.
Because succession does.
It cannot be.
Property.
You were also directed to maintain status quo, not to carry out the construction.
Your Lordship, if your Lordship is, there's also the second thing. There was no hearing that was done by the ADC of the petitioner. So there's been a violation of the.
Now,
principles of natural
ultimately,
justice as well.
because now the title holder, as per the title holder is only the father and the brother. I think there is difficulties in this case, it appears. So ultimately, the only option lies is to settle before or through negotiation, I think. But then this order has to go.
What I'm
Now, if you want to take one more chance, we can facilitate for mediation.
That is impossible, because he is unilaterally doing against all the brothers.
Now, see, they should also understand, because the brother, the petitioner, has no right, because he has no title, and in the garb of constructing house for mother, he also cannot, because mother is also debarred. Now, as per the Adi society, the custom, who inherits? Is this a ancestral property?
And eldest son, generally.
Who is the eldest?
Tojo Karga.
Now
He's-
that is also another dispute.
He's second,
Lordship. Now, if your Lordship may kindly take
You're
note of the
second.
name. If your Lordship may kindly take note of the name, Tojo Karga and Paknya Karga. So,
This
Tojo Karga is the son of Tumto Karga.
no,
Although biologically he is the son of Tumpak Karga.
your lordship is
Whatever may be,
was the
whatever
doc-
may be,
Hmm.
he right,
So
he right, probably Tumpak is the father,
yes.
as his father.
no,
Now
because
you cannot now
He doesn't
Say,
write Tumpak as father.
divide-
He writes son of Tumto Karga and his inherited properties of Tumto Karga. He's no longer
Tumpak.
a son of Tumpak Karga.
He has
Legally.
changed.
Yes, no.
Now he's no longer claiming the property also. Yeah.
He's trying to claim the properties. Now that is a different dispute again.
Oh, so many things.
So many things.
Hmm.
That is why this matter
And-
was sent for mediation, but then the other parties, they're not ready for.
And you say that it's very simple. This is the, I
No,
think,
the order of the ADC is very simple, Your Lordship. If Your Lordship will see, first of all, it's
now
not
see,
have the-
order per se, of course, will, even if it goes also, you'll be landed into trouble. So many things, you can't. Even if it goes also, you can't. It appears,
ultimately the
because the
solution is
land
to dispose.
doesn't belong to you. So,
Malad,
But
the
this order
problem
on-
is, Malad, if he forcibly starts constructing the house,
Hmm.
there will be violence, Malad. Because he cannot unilaterally claim the plot of land in saying that he's constructing a house for mother.
you don't have any other land?
Malad, that's the,
Not just,
Malad, it's there,
Hmm.
but this is a prime land, Malad, located near the road. Malad.
That's why everyone.
That's why
it has to be divided
That's why
accordingly.
he-
It has to be divided in between the
between the
brothers.
Yes.
And then other party, it comes, the title suit is still pending, you can't.
No, that's why, Malad. That's why
So many
he
things.
also cannot.
Hmm.
He also cannot. Saying
Okay.
that, but the matter is pending, so I will construct a house here.
Okay,
he-
so
he cannot do that,
what the provision says? This was also passed when?
2023.
ADC order,
23, after,
16th May.
Doesn't have the power. He has exceeded his jurisdiction.
Malad, how would the peace?
What else? What else? You are challenging this as well as only this?
And violation of principles of natural justice as well.
No,
Because
is this the only impugned order?
This is the only impugned order.
Now, if it goes, then what about he doesn't have even power. No, this power he has. But then
145 power.
this could not have, this FIR could not have been forwarded to ADC.
Because there was a chance of breach of peace. That's why the police
Okay.
said that
To club,
club together, Malad.
okay. So only with a view to pass order under 145 and
Yes,
147.
yes.
No,
That's what.
45.
Malad, he is also aware. That's why my lordship will see whom he has. This learned PP has also been made a party because he is aware that this was passed under 145 CRPC.
Your Lordship, all in all, I just have two submissions. First is that this, the learned ADC could not have passed this order because there's a pending civil matter that is already there before this honorable court. And I have two authorities with regard to that.
Where have you
Judgments
stated
of
that
the
civil matter is pending? Which paragraph?
Para 13,
Para?
13. Twelve also, Your Lordship. Para 12, 13,
13, what did you say? Civil code, just a minute. Huh?
para 12.
No, where have you said that the civil title suit is pending before the civil court? Where have you said? Para
Para
13 is regarding
Para 12.
para 12.
Yes, Your Lordship. That the petitioner begs to state that the additional Deputy Commissioner Kamba does not have the
the
power
petitioner
nor the
begs-
jurisdiction to pass an order of status
Okay.
or any such order restricting the petitioner. As the disputed land is pending judgment before this honorable court, which falls under the definition of civil court as provided under the Arunachal Pradesh Civil Courts Act of 2021, and hence any proceedings under section 145 and 146 CRPC cannot proceed once the civil court is seized of the matter, as the possession is eventually to be determined by the civil court, which in this case is the Honorable High
No,
Court.
you say the title suit is pending.
Title suit is pending.
Where is
Particular
it?
number, Your Lordship.
Hmm?
That is at para 10. The appeal against the judgment of the learned ADC Basar entitled suit 60 of 2024 is still pending before this honorable court as FAO number 1 of 2016. And since when the filing was done, the last.
So you
was on
have you
16th.
annexed the additional district judge order also?
Yes, yes, Your Lordship, I have.
Okay. Para 10.
The order of the.
The first appeal is pending before this court
Yes, Your Lordship,
against the judgment.
against the judgment.
Who filed this first appeal?
The other parties, no parties,
Okay, otherwise
the
it
one who's
is,
claiming the land.
okay, decided in your, in
In
father's
favor of
favor.
the
Who,
father.
who has been replaced? Who has replaced the father here in that appeal?
So far, I don't think any.
Father was
facts.
implemented probably.
Yes, Your Lordship.
Father is no more.
Father's no more.
Now, who has been, who substituted the father in that case?
I don't think there's any update with regard to that, Your Lordship. Nobody has substituted him. I think this honorable.
That
court
is
has not
important.
been
That is
intimated.
crucial again. And even for that also you have to decide within the family. For any region, I think this matter needs to settle between the parties. Okay, anyway, so this where have you mentioned the relevant provision under which the ADC doesn't have the power or jurisdiction? This is writ petition only.
Actually, Your Lordship, after the enactment of the Arunachal Pradesh Civil Courts Act,
Hmm.
there is the last section itself strikes out the name of the Deputy Commissioner and the ADC from the list of.
Where have you stated in your petition?
I've not stated the exact provision, but I've stated that there's no power, there's no jurisdiction.
Okay, what we'll do is we'll get it listed on Monday for order. I'll pass order on Monday. Okay,
Yes, Your Lordship.
get it listed on Monday.
Your Lordship, there are two judgments of the Honorable Supreme Court that I would like to submit.
What it says.
That once the civil court is seized of the matter, 145, 146 proceeding cannot go on.
But you also have filed complaint.
The mother has filed
Para 4
para 4
and
and at para 2 from
okay.
the 9th line, when a civil litigation is pending for property. First is that the civil.
Brothers have to stand together, it appears.
He is disturbing Maharaj. That's the problem. Now saying that
Now,
Building
now
code.
you see, in any case, you have to decide among yourself who will represent, who will replace your late father. That is crucial.
Hmm.
And then otherwise, an appeal, if the other side succeeds, then your fight goes.
now Maharaj,
And the second point is the violation of principles of natural justice because no hearing was done of the petitioner before passing of the order. These two are the main points.
Hmm.
Maharaj, the order
you
might be
file-
wrong or right, Maharaj. The ADC's order,
Have
Madam.
you filed any affidavit? No,
They filed.
no, no.
We have filed,
You have filed.
yes.
What you said in your
We
affidavit?
are saying, Malad, after all, the manner in which the proceeding has been done might be wrong, but it was passed under section 145 CRPC order, Madam. Ultimately, the aim of the deputy commissioner was,
But then under 145, the status quo till the decision of the title. But here
Yes.
he has decided a title itself, which he
no, Malad,
doesn't
he
have a right.
says, Malad,
power.
the manner in which the order was passed might be wrong, but the ultimate aim, your lordship, is since the order has been passed based on the application under section 145, Madam.
Okay, that is what you have said in your affidavit.
Yes, Malad. And we
Okay.
say, Malad, if the application is filed under section 145 CRPC, Malad, if the order is wrong, Malad, there's a provision under CRPC to file a revision petition before the learned sessions court, Malad.
Yes.
When there's
Okay,
an alternate
so
remedy,
the
Malad.
petitioner has come by way of writ petition.
Yes, Malad.
Hmm.
Alternate remedy is there. When there is alternate remedy, Malad, he cannot invoke the.
It's 226 only,
Yes,
not
Yes.
27 also.
yes, that's
Oh.
what we are saying, Malad. We have, Malad, this.
What it says, para?
Just a minute.
Hmm?
Yes, ma'am. Well, it starts from page, well, para 8 starts from last.
Para?
8,
8.
yes. Last page, ma'am.
Yes.
No, now so far as the Reliance place of decision of this court by learned Casino Council, appearing on behalf of respondent referred to here in above our consent. The question is not about maintenance of writ petition 226, but question is to about the entertainability of writ petition against order assessment. This is regarding text, madam. Assessment passing statutory remedy appeal. There are serious disputes on facts or whether assessment order was passed on such and such. No valid reasons have been shown by the SSC by past statutory remedy or appeal. This court has consistently taken the view that when there is an alternate remedy available, judicial prudence demands that the court refrains from exercising its jurisdiction under constitutional provisions. When there is alternate remedy, the writ court should not deal with it. That's the ultimate judgment. Here also, he has alternate remedy.
So she has, the petitioner is agreed by the executive order passed by the ADC.
Yes, madam. Obviously, under 145 CRPC. Though the order might be wrong, right? I'm not saying that, madam. But against that order, here's a remedy of revision petition before the Sessions Court.
Yes, if it is against 145,
Yes.
then it's a revision line.
Yes, alternate remedy is there. Therefore, he cannot come to this honorable court under the writ jurisdiction. That's what we are submitting. In a para 13, affidavit in opposition. Para 13, we have category stated.
Hmm?
In para 13 of our affidavit in opposition.
Whether record was called for? No.
No. Affidavit in opposition filed by respondent number 3. Para 13, Madam. We have got-
Yes.
Yes.
Yes, anything else?
That's all, Madam.
Okay, we'll get it listed.
Yes.
Okay, if there is any confusion.
Yes.
For further, hearing, otherwise,
Me.
order will be passed on the Monday. Okay.
Okay.
Uh,
Your
On
Lord-
Monday.
Hmm.
Lordship, if I may submit an authority with regard to the maintainability issue. There is a judgment of the Honorable Supreme Court which was passed in 2025 itself. Which states that even though an application has been filed under Article 226 of the Constitution, and the matter deals with the criminal procedure, the honorable courts can take up the matter if there is an abuse of the process of court. And the authority that I've submitted in that particular case law, your lordship will find the relevant paras at page number 6, 7, and 12.
para,
Para 6, para 7, and para 12. If I may just read the para 12, your lordship, on judging the case on hand with reference to the allegations extracted herein above, in the light of the decisions referred supra, we have absolutely no hesitation to hold that the High Court clearly erred in refusing to exercise the extraordinary power under Article 226 of the Constitution of India to quash the subject FIR number 64 of 2020 and all further proceedings in pursuance thereof. And para 7, it is written that the said position was reiterated by this court.
which
In-
one, para?
Para 7.
Hmm.
The said position was reiterated by this court in Pepsi Foods Limited and another versus Special Judicial Magistrate and others. This court held that therein the High Court could exercise its power of judicial review in criminal matters, and it could exercise this power either under Article 226 of the Constitution or under Section 482 CRPC to prevent abuse of the process of court or to secure the ends of justice. Furthermore, it was held that the exercise of that power would depend upon the facts and circumstances of this case, of each case. Now, in this particular case, your lordship will see that no hearing was also done, or the contentions of the petitioner was also taken into consideration by the Honorable ADC before passing the order. So that has led to a violation of principle
But whatever may be, the order was passed under 145,
145.
Hmm.
So usually what,
rightly or wrongly.
yes, your lordship. Because they have said that we could have either come under revision or we could have filed a criminal petition. But this honorable court has the power under Article 226 as well to exercise its jurisdiction.
You specifically, it appears that have said that you are aggrieved by the order passed under 145. Then,
Your lordship, through this judgment, what I'm just showing this honorable court that under Article 226, when there is an abuse of a process of court, or in case there has been
but then the proceeding was under 145
yes, your lordship.
and you participated in the proceedings.
I did not participate in the proceeding because I did not appear, nor was any of.
No, you said that the complaint lodged by mother also clubbed together.
Yes, your lordship, the mother, not the petitioner. The petitioner is completely different. And the notice was issued to the petitioner, but The petitioner never appeared before the ADC and he passed the order.
But the
That's
petitioner
correct.
can construct house on behalf of the mother, on behalf of mother. For
That is
mother.
That depends on the fact.
So many things.
Equity, this is law and order problem will crop up, madam. Otherwise, how they will settle in the but between each other, madam. Brothers. Law has to definitely protect all of them.
Hardness. Dear Bhutia, Lana counsel for the petitioner. Also heard Mr. Peter Poh. Lana counsel appearing on behalf of the. No. You are also?
Government is there.
Yeah,
but-
government is there. Yes, what is the submission of the government?
For one lordship. Lordship here, lordship. Now, situation very tricky, lordship, because lordship, as per the lordship, this new amendment lordship, Arunachal Pradesh Civil Court lordship, it is already been deleted lordship, the power of the SDC, ADC lordship, that is their lordship. And moreover, lordship, as per the, I have got through the lordship, this 145 lordship, that there's the order, impugn order lordship, that is their lordship, because some to avoid lordship, some disturbances lordship. At that moment, lordship, that interim order was lordship passed lordship. So lordship, as per the lordship submission lordship made by the lordship, this council lordship, the respondent lordship, there are certain lordship way of the lordship revision lordship is their lordship to challenge the lordship any kind of lordship 145 lordship order lordship that is passed, that is there also lordship. So lordship. So let's say in the fairly submitting lordship, that is up to the lordship discretion lordship, whatever order may pass lordship.
Discretion is always there. Okay,
Much obliged.
Miss El Hagi. You are also appearing, PP itself. Two. You have filed. Okay, saying what? ADC. ADC also made party.
ADC, yes. It is only to avoid this law and order problem. This status quo order was issued by ADC. law.
What you have said in your affidavit? Only to avoid, to prevent the law and order problem.
Yes.
Paragraph, which
Para-
paragraph you have stated?
8,
8,
13.
8 and 13? No.
So we put 11, 10, 8 and 11.
Okay. Miss N. Lawang, not a PP for the respondent number 2, and Mr. Tapo for private respondent number 3, huh? Stop. Say they are present, huh? List this matter again on Monday for further hearing. We'll say further hearing. I'll try to dispose of. Okay. If not required,
Your Lordship, I
may not be.
will not be available.
No problem. Hearing otherwise done.
I can,
But then let me see, just let me confirm. I'll pass order on that day if there is any case, any confusion, for clarification, it will be listed. Okay, so thereafter, okay, I'll pass order.
DPR.
Item number 6.
May it please your lordship, my lords, I'm appearing virtually in this matter. My lords, this is a writ petition which was filed challenging the demand of GST on annuity payments. As this matter was first heard on 4th March 24, and my lords were pleased to grant some interim relief in this matter, since a similar matter is also pending before the Guwahati bench of this honorable court. My lords, it was last listed on 18 June. Pleadings are now complete in the matter. So my only request is, my lords, if it can be listed any time after vacation, we're being led by a senior, he'll travel and come physically and make his submissions in relation to the same.
Okay. Miss, you are Miss?
Mannat,
Miss?
Miss Mannat,
Islamic
my
Council
lords.
for Islamic Council for the petitioner. Praise for listing this matter. When you said?
My
When
lords,
do you want, you said?
28th, 29th of Jan, if convenient to my lords.
Okay. Listing, pray for listing this matter on 28. Say 29 January, huh? To which Mr. Amkato, planet DSGI. Plan,
At the time for the Union of India, ma'am.
oh, yes. For the respondent number
One.
1 has no objection. Prayer allowed. List is matter on 20. As prayed for, come on, let this matter be listed on 29 January.
My lords,
Okay.
interim order to continue. my lords.
29.
Yes, my lord.
The interim order passed earlier shall continue till the next date of listing. Okay.
Much obliged, my lords.
Item number 7.
May I please?
Yes.
Well, this is a small matter. Well, this matter can be disposed of with the directions to the respondent authorities to give a directions to the printing authorities to publish my name in the official gazette, madam.
Your lordship, in this matter, we have received a letter from the Deputy Commissioner, East Siang District, SEPA, your lordship. Inform that amicable solution has been reached between the parties, your lordship. This is the instruction.
Well, if lordship peruse the impugn order, wherein the specific mention has been made that there is a the personal dispute between the two parties, that has been already resolved, and some amount has also been paid to the other party, madam.
Have you received the copy?
Yes, ma'am. Just I am informed also, that the issue between the parties has already been resolved. Now, my name can be published in the official gazette, the Gazette of Arunachal Pradesh. There is a procedure for publication of the names in the gazette.
Okay.
Just may I take your lordships to page number 118.
Yes.
Page number 118 and
Yes.
6. And the Deputy Commissioner had written a letter to the Director of Printing, Government of Arunachal Pradesh,
Not to print.
not to
Okay.
print,
Okay.
It's because there was a dispute, Now, dispute has been resolved. Now, Deputy Commissioner
The
can
page, you said page?
page number 118, 118, annexure 6. Request to keep the Gazette up notification of title / surname change on hold regarding change from Taku to Tana. We are Tana. This is to inform you that this office has received applications from the certain individuals that seeking a change of their title / surname from the Taku to Tana for the purpose of Gazette notification, which were forwarded to you on 28 April 2025. and list enclosement. However, there is an ongoing dispute between the Tara Av Welfare Society and the Taku Welfare Society regarding their this proposed change. As the matter is yet to be amicably resolved or formally settled between the concerned parties, any further actions at this stage may aggravate the situations or prejudice the ongoing deliberation. In view of the above, you are requested to withhold the publications of any gazette notifications pertaining to this title / channel change from Taku to Talan for the Tana for following applicants until further instructions from this office, Malad. So accordingly, Malad, the director printings, Malad, withhold the publications of my surnames in the official gazette, Malad. Now the matter has been amicably resolved. The deputy commissioner can be given, Malad, can be issued a notice, Malad, the direction to Malad send press notice for publication, Malad.
So can dispose of.
Malad. That direction, Malad.
Heard Mr. M. Kato, Land Counsel for the petitioner. Also heard Ms. Pangu, Land Government Advocate for the state respondent. How many respondents are there?
Malad, altogether, three, Malad.
State is respondent number 1.
Secretary, Malad, General Administration, Malad, he has nothing to do with. However, Malad, the deputy commissioner respondent number 2.
Your
Or-
correspondent, Pangu is 4.
1, 2, 3, Your Lordship.
All
All respect.
Malad,
State
direction can be
respondent one,
directly
two,
given
three,
to the Malad, the respondent number 3, director printing. Matter is already fixed, pending before the Malad director, Malad.
This writ petition has been filed. So the petitioner filed this writ petition, challenging the communication dated 13
Correct.
13/5/2025 issued by the Deputy Commissioner East Siang District SEPA,
Is coming.
East Coming
Yes.
District SEPA, whereby the director, within bracket printing, Government Printing Press, Government of Arunachal Pradesh, has been requested to withhold the publication of any gazette notification pertaining to the title stroke surname change from Taku to Tana. Plan, in respect of the petitioner until further instruction from the said office. Stop. It is submitted that the matter has amicably been settled between the clan brothers. It's a clan brothers.
Yes, Malad. Not exactly credible, Malad. Earlier, I was in the surname of Taku, Malad. After Malad, the discover of the Malad, my original surname, I changed to Malad Tana, Malad.
Okay. Between the amicable. What did I say? So the matter has amicably been resolved. It is submitted
Taku
that
Welfare Society.
now the matter has amicably been resolved between
Tara Ave Welfare Society
the
and
Tara Ab Welfare Society and Taku Welfare Society.
my lord.
Staff. In Miss Pangu, Land Government Advocate. While placing the communication. Then while placing the letter dated 18/11/2025. Written by the Deputy Commissioner, East Kamen District, SEPA, addressed to the Director of Printing, Government Printing Press, Arunachal Pradesh. Submits that since the matter has amicably been resolved between Tara Ab Welfare Society and Taku Welfare Society, now the Deputy Commissioner has already wrote letter by this letter has already requested the Director of Printing, Government Printing Press to proceed with the publication of the said change in the change of the title surname in respect of the petitioner in the Gazette by publishing in the Gazette notification. Stop. The letter dated, the said letter dated 18/11/2025 is taken on record and marked as document X for identification. Huh? In view of the above, the petitioner, the parties, in view of the above,
Madam, the annexure 5 series, page number 86, madam. Application, madam,
page,
86, madam.
what is that?
It start from page number 86 up to, madam, 117, madam. Application forwarded by the Deputy Commissioner, madam,
Okay.
for publication. Page number 86, madam.
86.
Yes.
Okay, these are the name of the. What are these?
These are the, madam, the applications to be, madam, the published in the official gazette.
Okay.
madam. Petitioner's name, madam, individually, madam, the
These
altogether
writ petition
32 in
stands
numbers.
disposed of with the direction to
The respondent number 3, madam.
the respondent number 3.
Yes.
To
Publish the name of.
take steps for publication of the name of the petitioners.
Yes, madam. Petitioner 32 in numbers, madam.
Petitioner from petitioners.
Yes.
Petitioners. Do we need the name from petitioner number 1?
But, madam, the forwarding letter.
32 in numbers, huh?
Yes, madam.
32 in numbers.
As per the, madam, the forwarding letter dated, madam, 28 April 2025, madam. Annexure
As
Five.
per page
86, madam.
as per the forwarding of the application for Gazette notification. For change of surname in respect of the petitioners. Okay.
Madam. Annexure 5 series, madam.
Okay, mention annex within bracket annexer 5 series, huh?
issued by the Deputy Commissioner only.
Issued by the Deputy Commissioner, East Cameng District, SEPA. That's all, I think.
My lord.
Okay, with the above, this, with the above direction, this writ petition stands disposal. Okay, allowed and disposal. Okay.
Yes, your lordship.
Okay, no, some rest at 2. Is there any urgency? We'll continue at 2, at 2. Okay, I'll come back. Huh? Yeah. Yes. Is there any advocate from the Guwahati?
Matter pertaining to principal seat, item number 1, IS civil number 3954 of 2025, along with MAC appeal 363 of 2025.
Yes.
May it please your lordship. Lordship, this application is filed by the claimant respondent. I am appearing for the appellant respondent, my lord. Appellant. In this case, we have prepared.
You're for? Appellant. IA is filed by whom?
IA is filed by the claimant respondent, my lord. I am for the appellant.
Okay. He is present.
He is not here,
Is
my
he
lord.
present?
He is not.
Okay, you
present.
have any objection?
No, my lord. That I will have no objection, my lord.
Only,
That correction of case number, my lord.
correction of case number only from 18 to 16?
Yes, my lord. Yes, my lord.
Directed at place of, okay, 16 to 18 only?
Yes, my lord.
Okay. Mr.
T. Kolita.
Who is for the applicant?
He is Mr. N. Borua, my lord.
N. Borua, planning counsel for the applicant. Applicant is a claimant. Claimant.
This is filed by the claimant.
Applicant is a claimant.
Yes, my lord.
Claimant respondent, huh? Applicant stroke claimant respondent, huh? Also heard Mr. Saikia.
T. Kolita, my lord.
No, sorry, Kolita. Planning counsel for Mr. Kolita, you're for?
Lordship, I am for appellant, my lord. And in this IA, my lord, I am
Appellant.
appealing for the respondent, my lord, as respondent.
Respondent number?
Respondent number 1, my lord.
Respondent number 1, stroke appellant. And are you also appearing here?
Lordship, I'm
The
the
other one?
courtmaster actually.
Okay. Sorry. It is submitted that in the order passed by, in the judgment and order dated 29/5/2024, passed by this court in MSC, passed by this court, the case, the name of the case, the case number is mentioned as MSC within bracket that case number 80/2016 instead of MSC that case number 80/2018. Stop by by filing this application, interlocutory application, the applicant stroke claimant respondent, prays for rectification of the typographical error of the above the typographical error appear in the case number. The stop the prayer is allowed. Stop para. The accordingly the case number MAC that case number 80 stroke 2016 stands corrected as MAC that case number 80 2018 in the order in the judgment in order dated 29/5/2024. Stop with the above this IS stands allowed and disposed of. Okay.
Highly obliged.
Is it okay?
My lord.
Okay. Okay.
Item number 11.
Yes.
Lordship, the petitioner has taken a steps on service report against respondent number 5, or former respondent.
Yes. You're for. You are for respondent,
I'm for respondent number 2, 3, and 4, Your Lordship.
2, 3, and 4.
Yes.
Okay, state for 1.
One.
Okay, so pro forma respondent. Are you filing any affidavit?
We'll be filing an affidavit, Your Lordship. If Your Lordship just give us some time, Your Lordship.
Okay. You also?
No.
Okay. Mr.
Lordship, I would like to pray that next date may be fixed on 19th of January.
Okay.
And by that, respondent may file all the affidavits.
Okay, your good name?
N. Rungri, Nabam Rungri.
Mr. N.
Rungri.
Rungri, then counsel for the petitioner. Ms. Wang Mo, then government advocate representing state respondent number 1, some state. The state is not filing any affidavit. Ms. Jin, then additional PP for the respondent number 2, 3, and 4, prays for further 2 weeks time to file affidavit.
If I may pray, Your Lordship, if this matter is fixed on 27, because on
20?
19, 27, Your Lordship.
Of January?
January.
Okay.
Because 19,
Prays for further time to file affidavit. Please pray for common. Let this matter be listed on 27. 27 January. Okay. Okay.
DP.
Item number 12.
May I, my lord? My lord, then I come out from Election Commission Bureau to 2024. As per last order, I was directed to take steps. And it is learned that all documents has been arrived. As of now, my lord, I'd like to pray for directive step for calling of official witnesses. I may allow, my lord, I pray for allow me to take steps for summon to calling appearance of official witnesses.
My lord, if I may, I think the document which is on record is Xerox copies, not the original sets.
You have an objection?
No, I mean the document has to be in original, so.
Okay.
Office note dated 12/12/25, it says document receipts. But I think it's a Xerox document, so.
You are for?
I'm for the respondent, SK Deori, on behalf of SK Deori. I'm
Okay.
also on record, Somila.
The document has arrived. I have received the document.
Yeah, my lord, it is,
Hmm?
it is learned that documents have been arrived here.
Where is the document? Sphere. Okay. Have you seen the document?
My lord, I have got through the documents, yeah.
You have got?
Yeah.
Okay. So it's all right.
It's all right, my lord.
No more documents is required now.
No more documents is required. Only it is to be exhibit.
Hmm?
It is to be exhibit before Your Honor.
What next?
Next, my lord, my prayer would be allow me to take steps for issuance of summon to official witnesses for their
Why?
official witnesses for their appearance.
Whether the petitioner has been examined? Cross-examined?
For cross-exam, yeah, my lord.
Cross-examination of whom?
The official witnesses for RO.
Okay, you have already been examined. Whether
my
the
lord.
petitioner, election petitioner have been examined.
No, my lord, till not. Yeah.
Then why should we call the official?
After
You
arrival
should
of,
be the first person to be examined and cross-examined.
exactly, my lord.
Yes. What next?
What cross-examination of these official witnesses?
Why? It has to be started from the with the election petitioner only. He should be the PW1.
My lord, yeah.
You want to examine the official witness first.
No, my lord.
Then see, court cannot guide the entire thing. That is why I have indicated you earlier also.
My lord.
See, all the procedure, what next is to be, you have to take care of your own case.
I have already submitted, my lord, list of witnesses.
Okay, what next then? What next now?
This is cross-examination, my lord.
Cross-examination of who?
Myself and for the official witnesses.
Have you exhibited the documents?
After exhibit, no, it's still not.
Have you given affidavit evidence?
My lord, I have submitted.
You have given.
Yeah.
You need to exhibit your documents first. Have you exhibited?
My lord, no.
Not yet.
Yeah, it is so that has to be fixed for exhibit of documents, my lord.
Yes, what do you say?
Should not state may be fixed for evidence. Because my senior, he was there yesterday, but he was not.
You have objection? to the documents because it is Xerox copy.
No, Lordship, if original has come, then no problem.
You want original.
Original,
Is it your
Have-
case?
Lordship,
You want original.
original.
Are you for petitioner or respondent?
Respondent.
Okay.
Otherwise, if the document have received, he have no objection, then it's for evidence. Based.
My lord, this is my copy of affidavit. Mr. Yasin Jongsam, petitioner in person. Also had Miss
Samila.
Land Council for the opposite party number 1. Start. Which are these documents? Document which have received, where have you mentioned these document, name of the documents? In your petition?
My lord, this is the step they have specifically mentioned here, the documents.
No, where?
List of documents, page number, my IA page number 4,
IA number?
4 and 18, my lord.
Hmm?
For page number, IA number 139, 136. Page number,
136
page number 4 to 18. Detail
4 to
18, my lord. List of documents to be filed by applicant, page number 4. Election notification. From here,
So which are the document which we have received this time? Official witness, which are the document which have been received?
documents
Mentioned in serial number
1, election notification,
and that we have received.
received, my lord.
Election notification.
Yeah, my lord.
Okay, and which one?
Exhibit A, and copies of final result sheet
Okay, that also we have received.
received, my
It's there.
lord. Yeah.
Okay, and
And and printout of the affidavit nomination papers of the candidate for 2014 election. They have given a Xerox copy, my lord.
And what else?
And affidavit and nomination filed by respondent one during last general election, that is 2019. And affidavit
No, where that is mentioned? Name of the document, in the name of the document,
number
has it been
7.
mentioned?
Page number 7, my lord, mentioned here. Specifically, I have mentioned the documents.
Okay, just a minute. Serial number 1,
Serial number 1,
2,
serial number 2, not serial number 2. Serial number 3 has been dropped,
hmm.
and serial number also 4 also, my lord, is dropped. Serial number
Dropped?
5, yeah, my lord. It is just an application that I have submitted during the time of
No,
returning. A written
I don't
objection.
remember. By which order the serial number 4 was dropped? By which order?
It was in last order, my lord. As my learned counsel has opposed about that the decision, this could not be produced.
4 was not dropped.
4 was not dropped, my lord.
See, what are you
But-
submitting?
But
4
they have
was not dropped.
not dropped, but they have not furnished the documents right now.
That is what I'm asking you to point out, which documents we have received. 4 not received.
4 not received.
What do you say then in this regard?
If they don't furnish, my lord, what I think is that if they don't furnish, the copy is with my petition, and I have already filed in the petition, and from that we can go ahead. What I think, my lord.
4 is not required.
It is right as of now. It is not required, but during the pleading, during argu, I will produce the documents that I have attached in my petition already in my petition. My-
It is in your petition.
Yeah, my lord.
Is it in your list of documents?
My lord, yeah. It is in the list of documents.
Okay, 4 you will produce, not required.
Not required, my lord.
It is with the document, with the petition.
Petition already filed in my enclosed in my petition.
Then why you ask for production of this document?
But during this, my lord, they will taking time. So for early adjudication of my this case, so that's this application is with already filed in my petition and is with me. Xerox copies with me.
Have you annexed this serial number 4?
Annexed, yeah, already annexed, yes, my lord, in petition number. Annexed in petition, in my petition, page number 38, annexer E, as annexer E,
That is available.
available.
Then why did you ask this?
To prove that I have not verbally, I have objection, but in written also I have object this discrepancy during the time of this scrutiny.
So now you are submitting that document 4 is not required to be produced by the official witness as it is as it is annexed along with the petition.
My lord,
This is your submission.
my lord, yeah. Otherwise it will take time.
Okay. Then
Then 5 is available. They have
5 was dropped, I think.
the 3 was dropped, my lord. Earlier 3 was dropped.
Okay. Five is,
is just, five is 2014 affidavit filed by respondent number one during the last election, 2014 election.
this is not available,
Available, my lord.
available.
Yeah, is rich here.
Oh, it is present here.
Yeah, my lord, present there.
Five is present.
Five is present, they have furnished.
Okay, and
All records they have furnished, my lord, right now.
five, six also.
Six also they have furnished.
Seven,
Seven also they have furnished.
eight,
Eight also.
nine,
Nine also they have furnished.
10,
10 also furnished.
11,
11 and 12. These are two letters which I sought from the chief electoral officer. But that's why returning officer Changlang has furnished the copies there, madam.
eleven, 12 is not there.
11, 12 is not there. They have not, but the returning officer Changlang has furnished a copy of this documents, my lord.
Where it is available? Is it available?
It is available there, my lord.
Returning officer Changlang furnished.
Changlang has furnished these two copies.
Whether returning officer Changlang was also directed to furnish a copy.
No, I was not directed. I was not seek from Changlang, but I sought from the chief electoral officer Itanagar, Nirvachan Bhavan. But Changlang has furnished this copy, my lord. Aro Changlang.
Returning officer Changlang was also directed to furnish the document.
No, my lord, I was not. I have not mentioned this about from Changlang. This was specifically mentioned.
No.
From
who directed the returning officer Changlang to produce this document?
That, my lord, that I have no idea. They might have official correspondence. This is my taken for production of these two documents from Itanagar intellectual property.
What is this?
This 11 and 12 specifically sought from Pavan Kumar Sain, Chief Electoral Officer, Nirvachan Bhavan, Itanagar, for these two copies. But returning officer Changlang has furnished these two copies, madam.
To whom?
Here.
Whom the returning officer Changlang has furnished this document?
To honorable court, my lord. Yes.
Okay, whether this court has directed the returning officer Changlang to furnish this this document?
No. I have no. This court has not directed.
Then why he has furnished?
That I don't know, my lord.
He has volunteered. How this returning officer knows that these documents are necessary? Where in the documents? Is it available in the court's document?
Available, my lord.
Okay, where? Petition?
In petition also, my lord. In their petition also.
Whose petition?
Opposite the respondent number one, they have filed in petition. Here also they have enclosed these two petition earlier. These two documents. In their petition.
In your petition also it is annexed.
I have annexed, my lord.
Then why you have asked this document?
These two documents that I have not furnished, my lord. But this is their documents, so that I have that I have to mention it. Why this number 10 notification is also not my documents, my lord, but they have furnished in their IA. So that's why I have to sort these documents, my lord.
This was to be furnished by whom?
These two documents I have sought from the Chief Electoral Officer Nirbachan Bhavan, Itanagar.
Chief Electoral Officer Nirbachan Bhavan, Itanagar.
My lord, yeah.
They did not furnish,
They did not furnish.
but it is already furnished by the respondent.
No, returning officer Changlang, yeah, respondent, RO.
Whether a returning officer Changlang was also directed.
I sought, my lord, the document mentioned, specifically mentioned is this my step. Yeah.
On whose direction, order or instruction the returning officer Changlang has furnished this document? What is this?
These are steps that I have taken for requisition of these documents, my lord.
The office note dated 12/12 para 2025 reflect that the document has been received from the official witness Sri Vishal Shah, ISDEO, come returning officer Changlang. Stop. In this regard, the petitioner in person submits that he has received the copy of the document furnished by the returning officer. A copy of the document have furnished by the official witnesses, staff. He has confirmed the receipt of receipt of the document. Receipt of the document under serial document on the serial number. Document mentioned under serial number 1, 2. Five, 6, 7, 8, 9, 10. So if other sum is that the document under serial number 4 is not required to be furnished by the official witness as he has annexed in his petition. Document number 4, you have annex as what annexer? Annexer number?
Annexure number E, page
Annexer
number 38 E,
of the election petition,
my lord.
38.
38, page number 38.
Annexer E at page 38. Hmm. Which pertains to the written objection filed by the election petitioner against the 3 affidavit filed by Wan Sri Tesam Pongte along with his nomination paper. Okay. And document mentioned under serial number 11 and 12 is 11 and 12 according to the election petitioner has been annexed by 11 and 12 was annexed by you.
No, not me.
No, annexed by whom?
Annexed by, this is their documents. So I have
Okay.
got it from,
Okay, 11 and 12 is what is this document?
this
This
is
is
my lord,
Talabana.
my lord, this is an order from Chief Election Officer.
No, you have furnished these 2 copy.
Oh, this is my, the step that I have taken for requisition.
Why you have shown this step? 11 and 12, what are these documents? You said that this is available. Where it is available?
It is available in your, in this
The
page number.
the last one you write like this. The election petition also submits that the document under serial number 10 and 11, sorry, 11 and 12 are also not required as it is annexed in the कहाँ पे annexed? Where?
Page number 234, 35, my lord, in election petition, India I election petition. This is, they have filed an election, this IA.
Huh? They have filed?
Yeah, they have filed.
IA.
IA. In this IA, they have enclosed this, this document, 2 documents. So I
This
have.
IA is for what?
I was for dismissing of this, my main election petition, but it was dismissed. This IA was dismissed, my lord.
Dismissed, disposed
Already
of.
dismissed, disposed of, yeah.
You want to use that document?
No, they have, yeah. That's why,
Document annexed and disposed of.
so that's why I have sought these documents, my lord.
Now, why you are submitting that these documents are no longer required? It's not required.
Not required, my lord. That's why I sought it from this election commission, this Pawan Kumar Sain.
Okay, whether the Pawan Kumar Sen has
No, he
produced
has
this
not sent.
document?
Yeah, he has not furnished the documents. Instead of that, the returning officer Changlang has furnished. That's why I'm saying all
Oh.
that.
Changlang has furnished to whom?
The here, honorable court, my lord.
Is it available before
My
in the
lord,
court's
yeah,
record?
yeah, my lord.
Where?
The document.
By way of filing affidavit? Or just,
No, today the evidence, my lord, in documents that which I have sought from Changlang.
whether this court has asked the returning officer Changlang to furnish those documents?
No, my lord,
Okay, why he has furnished then?
that I don't know, my lord.
So how do we record? You want this document or you want this document, huh? Where it is available or where can we record that it is available? Hmm?
This documents is also available in returning office, is available with returning officer at Changlang. But I have sought it from Itanagar Chief Electoral Officer.
Is it available? This is issues only. Letter dated so and so. And letter dated 23, 24, 22, 20. What are these letter?
This is letter from Election Commission of India, my lord.
This document is available.
Yeah, available, my lord.
And where?
The Changlang is available with RO Changlang, District Election Officer Changlang also.
Okay. RO Changlang has furnished.
Yeah, furnished
To whom?
to this court, my lord.
Okay. Whether this court has asked the RO Changlang to furnish this document. By which order? Why he has furnished?
That I don't know, my lord.
What interest the RO Changlang has got in this election petition? He volunteered to furnish those documents before this court. Hmm? Where are those documents? How do we record? Hmm? Where are those documents? These 11 and 12.
11 and 12 with District Commissioner Changlang has furnished, my lord. a copy.
Where is that?
Last page में हम देखा जितना लगा था जो the document which arrived from Changlang, affidavit and all in last page they have enclosed
How
furnished
is
these
that,
two
huh?
copies, my lord.
Is there any direction?
There is no direction from my lord. There is no direction from honorable court to furnish these letters from RO of Changlang. In my step also,
If
I have
there
not-
is no any direction, why the RO Changlang has furnished or deposit the document has been just a minute. Vishal Shah. Returning officer Changlang is Vishal Shah only. Vishal Shah has furnished.
my lord, he has furnished.
Is it Vishal Shah who furnished?
My lord, yeah.
Is it along with the document which he has furnished?
My lord, yeah. This is along with the documents, yeah.
Along with the documents?
Yeah, my lord.
Where?
The last page.
Hmm? Which one?
May I please, my lord?
Yes.
Otherwise, let me allow to take dusty steps for these two documents.
Wait, let us decide where these documents come from. What Dusty?
For these two documents.
One comma three. Letter. Two documents,
Yeah, my lord. 11 and 12.
11 and 12. You said that it is available here?
Yeah, it is available, but it is available and it is furnished by the RO Changlang. If it is required,
Where it is available?
the documents which they have furnished, I have.
It's
shown-
available here.
Yeah,
Which one? Have you seen?
I have seen, my lord. The last two, these two copies is also is enclosed there. This is.
Can you find out from this petition? Flag it, huh? Those two documents furnished by the is available.
This, my lord, these two copies are reproduced by Joint Chief Electoral Officer Itanagar. One is from Election Commission of India. This is reproduced by Joint Chief Electoral Officer.
Okay. Then in the earlier document only. What are you saying? Creating confusion. Then 10, 11 and 12. Okay. So the above documents are marked as document B series
Exhibit L
for
Exhibit L, Exhibit M. My lord.
exhibit.
L and Exhibit M.
Has it been exhibited?
No, just I have mentioned as exhibit, not yet exhibit.
B series for identification. What next? What next to be
Next,
done?
my prayer, my lord, allow me to take a step to summon official witnesses for cross and all this.
And according to you, what next?
I think next will be for evidence. To exhibit
Next,
the document.
exhibit the documents. After that,
Next date is fixed for since the document is sought for by the election petitioners. from the official witnesses are also received. The next date is fixed on when?
Lordship, after vacation.
As per convenient of my lord, as per your convenient, my lord, as per convenient of honorable court.
This court is convenient for tomorrow.
Okay, my lord, I am ready. And one more, may I please, my lord?
After vacation.
May I please, my lord, please accept my affidavit as chief in chief.
On just immediately before the on 23, huh? We'll fix it on 22,
My lord,
23
my lord.
23 of
December.
December 23rd, there is another election matter fix. Yesterday we fixed for 23rd, if I'm not wrong.
We'll fix it together. Okay. For exhibition of the document by the election petition. Okay.
My lord, much obliged.
All right.
Item number 13,
Properly managed, huh? Yes.
Ma'am, respondent have filed their replies. So today I'm praying for some more time to reply the affidavit filed by respondent.
You are for?
I'm for petitioner, Your Honor, my lord.
What is your submission?
Respondent have already filed their reply in
Okay.
affidavit. So
Okay.
my lord, today I'm praying for some more time to reply the affidavit filed by respondent.
Mr.
Estana.
Land Council for the petitioner submits that he has received the affidavit in opposition filed by the respondent and prays for some time to file affidavit in reply. Stop. Mr.
Your Lordship, I'm appearing on behalf of Learned DSGI, Mr. M. Kato.
Okay, you are Mr.
T. Meto, Your Lordship.
Land Council is also present on behalf of Mr. M. Kato, Land DSGI. Stop. Is prayed for Kama. The 3 weeks time is granted to the petitioner to file affidavit in reply. List this matter after 3 weeks.
Oblige, Your Honor.
item number 16,
Yes.
My lord, I am enter appearance for the first time, my lord. Correspondent number 5 to 20.
Okay, none appears on behalf of the petitioner on call. Mr.
M. Doji, my lord.
Land Council would appear on behalf of the private respondent number
5 to 20, man.
5 to 20. Okay. And Ms. Sangeeta, Land Council, and I'm a government advocate who's also present on behalf of the state respondent. Start. What is this matter listed?
My lord.
Are you going to file any affidavit?
Yes, my lord.
Okay, Mr. His name, and praise for how much time?
3 weeks, my lord.
3 weeks time to file affidavit in opposition. Prayer allowed. List this matter after 3 weeks. Okay.
Oblige.
item number
It
17,
is present, maybe recorded. Huh? Okay. Yes.
May I please, Your Lordship?
Yes, please.
My lord, this is a co-warrant of petition, my lord. Co-warrant of petition challenging the continuance of the appointment of respondent number 4, my lord. That his appointment is hit by Article 319 of the Constitution, my lord. Your Lordship may kindly, just for a brief fact, Your Lordship will kindly go through paragraph
Just a minute.
paragraph 6 paragraph 7, page 7, my lord, of my petition. That's shortly, my lord. Wait more. At page 7,
Just a
at
minute,
page
huh?
7, paragraph 2. Only 3 paragraphs that may clear my position, my lord. Paragraph. Paragraph 6, one.
Just a minute, huh?
But that by order number so and so, dated 11/3/24, see, studying Nakasa on the recommendation of search committee,
Just a minute, huh? This is listed
page
for
7.
order. This is today, it is listed for order.
That is a read petition, my lord, not a major petition.
Hmm?
That is a read petition at read petition, my lord, at page 7,
What is there?
page 7, paragraph 6.
Just a minute, sir. Just a minute.
That is a fact of the case. Only by these 3 paragraphs, my lord, you also will understand the position of the case. What has happened, my lord?
Page?
Page 7.
Just a minute.
Hi, Charles, you got it.
Just studies. Yes.
Down below is a page, paragraph 6, down below.
Page 7, paragraph
6.
6. What is this? Yes.
6. That part order number 24, dated 11/3/24, Sri Sering Nakasa, on the recommendation of search committee, page 8, dated 7/3/24, the Honorable Governor of Arunachal Pradesh appointed Sering Nakasa as the chairman of the Arunachal Pradesh Private Educational Regulatory Commission 2017 for a period of 3 years or until he attains the age of 65. Ignoring that, he could not have been appointed in view of provision of Article 319 of the Constitution, as such appointment be declared void derogation. So, my lord, this is at Annexure 1, page 33, his appointment order. We'll go through that, my lord. Your lordship, kindly. Page 33, Annexure 1, my lord. On the recommendation of the search committee, dated 7/3/24, the Governor of Arunachal Pradesh is pleased to offer appointment of Sri Sering so and so to the post of chairperson of Arunachal Pradesh Private Educational Institution Regulatory Commission in the revised pay scale of so and so, so and so, so and so. The rest is not required, madam. Only we are questioning the appointment, madam. Next, madam, you also come to the next paragraph, madam, paragraph 7, at page 8.
Yes.
Page 8. The representative expressed based on record that Sri Sering, presently chairman of the Regulatory Commission, was formerly a member of the State Public Service Commission of Arunachal period during the period 13 to 17 to 12 to 23, immediately before his appointment as chairperson of APPERIC. The petitioner states that appointment is directly in contravention of Article 319 of the Constitution, which categorically prohibits that any reappointment of a former member of the State Public Service Commission under central or state. Copy of the 72nd edition of the Public Service Commission of Sri Sering Nakasa as member of Public Commission of Arunachal Pradesh on page 8, Annexure 2, that your lordship will get it at page 42, my lord. At page 42. The annexure begins at page 35. So 42 is the relevant portion, my lord. State Public Service Commission. That is a heading, my lord, page 42. Second, Arunachal Pradesh, so and so. At serial 5, you also will get Member Sering Nakatha, 13 to 2017, 12 to 2023. No, Malon, that is a whole story about it, Malon. That is a whole story about that. He was earlier in the State Public Service Commission. Then he is appointed to Regulatory Commission. Now, Article 319, it prohibits, it creates a bar that he cannot be appointed, Malon. That is a whole crux of that is a issue before your lordship, Malon. That how can he continue as a member of the commission? That is it. There are decision of the Himachal Pradesh Division Bench and as well as the Supreme Court, my lord. In Supreme Court, my lord, what has happened? The petitioner there questioned the appointment of governor. Then his lordship, my lord, that is a full bench chance, my lord, that it went to decide that governor, president, and judiciary, judges and all judiciary, my lord, they are not under the pay of the state government. So they are excluded from 319 of the Constitution. But rest of the persons who are under the pay of the state government, they comes under the ambit of 319 of the article, and that is the bar. That is the whole crux, my lord. Now, understanding this position, my lord, 319 that prohibits, my lord, my whole prayer before your lordship, my lord, there are two prayers. That is, one is the final prayer that your lordship will decide it at a later stage. My short prayer is that, my lord, his continuous, that means at page your lordship may kindly see at page 31, my lord. It's a short prayer, my lord. Page 31, my lord. Page 31. 31. In the intermediate period, that till the decision of the repression of all official acts or a commission and chairperson officiating as officiating by so and so of the one super be remains suspended. Now, what has happened, my lord? My lord, now, in his position, my lord, he is acting as a his role as a statutory chairman, my lord, acting in the public body. Therefore, if his appointment is questioned and prima facie there is a bar, so all official acts, whatever he has done, that has to be subject. Otherwise, my lord, that will create a difficulty, because a person who doesn't have any authority to remain in the office, that your lordship will decide it at a later stage. But prima facie, if it appears that his authority he remained in the office, so all official acts, whatever his official duty he did, that ought to be remain subject at least for a period of on the returnable date, maybe in January. So let the respondent come before lordship, they may pray for modification, rectification, whatever it is. There is always a power for your lordship to review child order. But actually, if it prepares that is a that it contravenes the Constitution,
So bar is under 319.
319, madam. That is correct. There is a bar, J bar. You also may kindly see, I have quoted Article 319 at paragraph 8. That is that pay as your lordship will find. So, yes, paragraph 8, page 9, my lord. Page 9. A, B, that is it, the union service model. D is the relevant provision for us at page 10. What is the union public service commission, my lord? We are not at that, my lord. D, a member other than the chairman or a state public service commission shall be eligible for appointment as chairman or any other member of the union public service commission or as chairman of that or any other state public service, but not for any other appointment under the, that is its own state, but not. That is where
So, but not for
But not-
any other employment,
yes,
either
Yes.
under the government of India
he
or
he
under the government of state.
he could have been appointed, my lord. That is where, my lord. In any other, maybe in Assam or any other place, but he could have been appointed. There is no bar to it, but not on in its own state. There is a whole bar.
Yes. So he has been appointed. Who are you otherwise? Just a minute. I haven't seen actually. Arunachal University of Studies. His post is, his present post is
Chairperson.
Page 33.
Chairperson.
this is under the state government.
Yes, madam. Chairperson of the Arunachal Pradesh Private Educational Institutions Regulatory Commission in
He is the chairman of
Regulatory
the
Commission.
regulatory commission
So this is under state government.
under state government.
Okay, so this is
That is one.
barred
And
by
under the
319.
payroll of under the state government as well as the payroll of the government.
Hmm?
Under the state government as well as the payroll of the government. You also may kindly see.
State government as well as.
In the revised pay scale of so and so, so and so, so and so.
Okay, okay.
That is where in the revised pay scale of so and so, so and so, so the government. So
Yes.
Supreme Court has distinguished its case, madam, in 1973 SCC 458, madam, Hargobind Pan. That judges as well as judiciary, they are not under the state payroll of the government. So 319 is not attracted.
Yes.
But it seems the writ petition is totally misconceived. The private respondent, Sri Naksang Seri,
Hmm.
He was, of course, not disputed that he was a member of the Arunachal Pradesh Public Service Commission. Under Article 319, there is a bar for re-employment or employment under the government of India or a state, any state. But if we kindly see Article 319, what it says. I'll directly Constitution. I wrote it in Article 319. Prohibition as to the holding of offices by members of commission on ceasing to be such members. Then on ceasing to hold office, A, I'm not concerned with A, B, C, D. D, a member other than the chairman of a state public service commission shall be eligible for appointment as the chairman or any other member of a union public service commission or as the case as the chairman of any
Of that,
of that or any other public service commission, but not for any other employment
either
either under the government of India or under the government of a state. Now the word used is other employment. Whether the post of chairperson of the Arunachal Pradesh Private Education Institutes Regulatory Commission is an employment under the government of India or under the state. It is a appointment under a statute. It's an appointment under a statute. It is the statute is called the Arunachal Pradesh Private Educational Institution Regulatory Commission Act 2017. That is at page 43. That is a statute, an act. Now, the question is here whether an appointment under the statute will be an employment under the state. I have decisions of the other high courts, even the State Information Commission, chairman or the member of a State Information Commission is not an employment under the government. The Lokayukta, member of the Lokayukta, because it's appointed under the state, under an act, those are also not under the employment of the government. This is not a simple interpretation that any appointment by the government automatically becomes the employee of the government. It is not they are not the employee. They have a fixed tenure for certain period. They are not employees who will be answerable to the government, who will be their service conditions will be like the other government officers, other government servants. So for today, we are ready to file our affidavit. We are going to file our affidavit. Today it was fixed only because there was an IA filed by my learned senior that to fix it for interim prayer. My lord will kindly see the very appointment order which is under challenge. This is of 11 March 2024. Already more than a year, almost going to be 2 years. Now, at this stage, the question of granting stay to the appointment order of the private respondent, it is 2024 March, 11 March 2024. At this stage, how can any stay be granted? Where were they when they initially this private respondent was appointed? At this distant point of time, they are coming up, and that too, this prohibition under Article 319 will not be applicable for this post. We'll file our detailed affidavit, and then this will require a hearing. Otherwise, I have decisions which, taking into the decision of this of the apex court, what my learned senior has referred to, all these decisions saying that these sort of appointments under the statute cannot be termed as being employment under the government.
My lord, to clarify his position, my lord, I have annexed the act, my lord. Kindly see at page 43, my lord. That is the Regulatory Commission Act. Who are the members? Section 3, establishment of the commission. At page, the act begins at page 43. At 44, 3, establishment of the state government may by notification publish the official gazette. Establish the Arunachal Pradesh Private Educational Institution Regulatory Commission for the purpose of providing regulatory mechanism in the state and for working as interface between the state government and the central regulator. That is in between the state as well as the Regulatory Commission. So this has got direct connection with the commission and the state government. That cannot be said that that is an independent body. It has no connection with it. For the purpose of ensuring appropriate standard of evaluation, so and so we are not concerned with this thing. Location shall be a body corporate, so and so, then composition of body, then you also will find that the pay scale, etc. At section 6, there shall be a secretary of the commission who shall be appointed by the state government on such term condition as may be prescribed. So is it a diverse body?
Yes. Okay, so you move this petition on 11:25. Okay,
1311.
13:11.
Then
It was on 12:11. Okay.
Section 15, members of the employee to be public servant. The members and employees of the commission shall be deemed to be public servant within the meaning of section 21 of the
Mhm. So let the state file affidavit.
That's the matter. What they want to fight. It's true, matter. Now, another factor he said, I do not have it. Let him. Matter. A person, he says about a person, that also has been dealt in the Supreme Court. A person who comes here in the state of Arunachal Pradesh, hold some land. He goes on for 1 year. Now the question is, by the lapse of this 1 year, when his detection is ensured, realized, can he claim that I have been sitting here for 1 year, so don't disturb me?
No, what is
So,
submitting is that he has,
let him file an affidavit.
the respondent
That
has
is
been
all right, Madam.
appointed under the
And
statutory.
regarding,
I think it's only for clarity, my lord.
kita file kembali tomorrow, very, so,
Para,
23rd of January.
para,
My lord, para, that is last page, my lord, para 11.1 and 11.2. Last second page.
hmm.
This is with regard to State Information Commission. Here also it is said it will not be treated as an employment.
Okay, so where it says that it's under the statutory, so the present is also under the statute.
Yes, madam, that it's under the post of chairperson.
Hmm.
Under or the commission, member of the commission, it is under the 2017 Act
Okay.
at page 43. Because this commission itself is created under this 2017 Act, the Arunachal Pradesh Private Education Institute Regulatory Commission Act 2017, page 43.
It's 43.
Yeah.
Okay.
This is the act whereby the commission has been created.
Okay.
Under section
19.
3 and 4, composition. 3 is establishment of the commission, 4 is the composition. The 4 talks about the appointment of chairperson. And the functioning of the commission. It's totally under a separate statute. Under this act, the commission has been created and the members have been appointed. Yes, tenures are also fixed. Powers and functions are also fixed by this statute, this act itself. Like under the RTI Act, the RTI commissions are appointed.
You file affidavit, then we'll have the hearing of the entire matter.
Yes.
We'll fix the date. We'll fix the date.
Yes, can a date be fixed?
Yes.
Maybe if it's
Okay.
convenient, Malad, let 23rd of January, Malad, after the.
Mr. D.K. Das, Land Unit Council, assisted by Miss P. Borang, Land Council for the petitioner. Mr. N. Ratan, Land Additional Advocate. I have also heard Mr. N. Ratan, Land Additional Advocate General for the respondent number.
He is for the commission.
Okay.
I'll be for 1 and 2.
1 and 2.
Pilot, may I also see whether notice has been issued to the respondent number 4? Steps have been taken or not?
Notice was directed to be issued. Notice was issued.
He is a private restaurant, Malad, he has appointment.
Have you taken steps?
Whether steps have been taken?
Yes, yes. There is a direction. Have you taken steps upon the respondent number 4?
Respondent 4, Malad, yeah.
You have taken.
Yes. By name.
Respondent number still awaited. It's still awaited.
Yes.
Still awaited.
Because otherwise it will be a defect on the read petition, Malad, because he is appointed by his question. Malad, my other prayer is that let the intermediate matter be heard on that day. Let us try.
And Mr. Jamo 4, respondent number 3. Okay. The office note dated 16/12/25 reflect that the notice upon respondent number 4 is still awaited. You want to take fresh steps or to ensure his appearance?
Steps has been taken.
Taken, but then it is still awaited. Since we are asking for a date, would you like to take fresh steps?
23rd of January, Malad.
23rd of January.
23rd of January.
Okay. January, since we are fixing on 23rd of January, the service upon the respondent number 4 is still awaited.
That's better.
What I'm asking is, would you like to take fresh steps since it is still awaited? It appears you have taken steps. No, recently only, December only. Okay. In view of the above, and as prayed for by the Lanka Council for the petition, not being objected to by the Lanka Council for the respondent, let this matter be listed on 23rd of January. Okay.
Let us sentence be there, my lord.
In the meantime, okay, just a minute. You also, you will also file affidavit? Okay, then, Mr. After this, and both, the praise for how much time? 2 weeks time to file affidavit.
Okay, my.
Okay. 2 weeks. Okay.
My lord, kindly make it 3 weeks, my lord.
Okay, 3 weeks. Okay.
Vacation is also approaching.
Okay. And then last will remain the same. Fixed 20 January. Okay. Okay.
Regarding interpret, the approach may be made.
Okay.
Regarding
On 23rd, huh? On which date the effort shall be made to dispose of the entire matter. Okay.
Item number 19 and 20.
Getting
Oh, 19. And 20. This is for hearing.
Yes.
My friend starts. To be fair, but I don't know whether it will be possible to complete it.
Hearing, I don't think it will be possible to complete today.
But
And
my lord, I am appearing for Union of India. I am having some urgency. Urgency is that, my lord, the army wanted to do some constructions, but the local authority is not permitting because the matter is sub judice. So maybe my fear is that, my lord, some part may be heard today and tomorrow may be fixed up at 2 o'clock. I will take hardly, my lord, maximum half an hour.
My lord,
Matter fixed for disposal. I don't doing anything.
my lord, otherwise, I'll just give a brief. What are the issues to be decided, and then let the AG make his reply because they have already filed 4 affidavits. In those affidavit, they have already on oath, they have said that there is no records of acquisition of land from the deputy commissioner and also from the government. So, my lord, since AG is will be going back, so let him make his small submissions, and then I'll start, and we will take it up tomorrow, my lord, since Mr. Doloy has shown some urgency. Lord, only facts are slightly long, but then the issue to be decided is very short. Whether the land in question were acquired as per law or not, whether the processes has been completed, and if not, whether the land will be taken on acquisition or or they will return it.
this is regarding?
This is regarding, my lord, there are 2 writ petitions, my lord, 187 and 186. My lord, the facts, everything are same except the area, respective area only. That is the only difference. So, my lord, 187 may be taken up.
No. Just a minute, huh?
But I have also prepared one small
No, it appears. No, this is long matter. It will take time. It will take time. It will be difficult. So if we have to start with,
We start today and then we continue tomorrow.
mm,
We can put it on the part and top of the order.
no, the court also will have some query for clarification.
One of the fact of the case is
Hmm.
we have acquired 1,115 acres of land in 1964 we have taken in a land.
63, 64.
Yes. Subsequently, what happened in 1972, we have acquired that plot of land.
Mhm.
And after that, my joint survey was conducted in 2003 and 2023. And after that, they have found 177 acres was excess occupied by the army. Subsequently, as per 2013 Act, that compensation has also been given. Now his grievances is that there is some another nearly 400 to 500 acres that is not acquired by the state government. That is the question.
Okay.
So
Only,
when it
only
is
to
submission
to
today,
determine it's whether that has been acquired or not. And then as my learned senior friend has mentioned, whether those processes which they are supposed to have taken up, whether those were as per law or not. I'll just show you lordship that it is totally the process has not been followed. There are a lot of lacunas and there is no compensation assessed, no payment made. Well, the provisions of Land Acquisition Act is a complete package. You cannot just issue notices under section 4 and 5.
Can you start on Monday? Next Monday? Then, if possible, then. Okay. So that is why. Hmm.
I have to come back on 5th of January for
Okay.
another one.
Okay.
So that is the reopening date after the week. Your doctor kept
No,
necessary, I'll stay back for one more week. Oh,
January.
on for the 6th is a holiday.
That,
In that case,
because
what are-
thereafter also, probably the holiday starts again.
yes, yes.
And then
13.
can be 13 can, no,
No, my lord, I am 19.
19, in that case, what? Like,
19,
necessary, we continue on 20.
19, 20, 19 can be.
Your lordship will fix it on 19.
Hmm.
We will continue 1 or 2 days, whatever is required. my
Okay.
lord.
But in that
19 would be
case,
better. It will be Monday. Okay. Mr. T party. Land counsel for the petitioner. He is present. Mr. Chaudhary and AG.
I'll be appearing for the state, madam.
General Court as eight. And Mr.
Why Dolo?
Then,
Why
can I
Dolo?
comment?
Your counsel,
Can I-
Union of India,
Hmm.
appearing for respondent number 1, 3 and 4.
1, 3, and 4 are also present on the request of the parties. Let this matter be listed again on 19.
But
Okay.
can it be on top, the first item above the admission column after
19, yes,
Can-
we listed at the
Has to
top
come
of
up
the
as the
hearing
first
list.
item in the hearing column.
Oh,
no, not hearing column. Let it be on top, my lord, after just motion because hearing that doesn't reach.
no, it is hearing only. Top of the hearing list.
My lord,
Okay.
That is there, my lord, but then it hardly reaches because this case has been coming up for number of days,
Mhm.
but somehow like this only comes up on the last moment. So because of paucity of time.
Not every day, but then it will reach. Okay.
Obliged.
Because on that day, if it we get less time, then next day can be fixed.
Yes.
And on the next date, it will be directed that the less matter be listed. Yeah. Okay.
Sorry, Madam, I am appearing for respondent number 2 also, 1, 2, 3, 4.
Okay, 1, 2, 3,
One.
4, huh? Okay. Oh, finish, okay.